55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
May be seated. In the cases of the People versus Christine Lillian Howell, counsel identify for the record, please.
Karen Tomczyk for an arraignment attorney for Ms. Howell.
You are Christine Lillian Howell.
Yes, Your Honor.
You're on probation on 2 cases. 18-5747-FH for controlled substance, possession of methamphetamine, second or subsequent offense, a felony that carries a maximum penalty of 20 years in prison. And 14 count probation violation is in that file. And you're on probation in file number 18-5881-FH. Controlled substance, possession of a narcotic less than 25 grams. Felony carries a maximum penalty of 4 years in prison. And a 14 count violation in that file. Ms. Tomczyk, you've gone over the violations with her, is that correct?
I have, Your Honor.
All right, and how do you wish to proceed today?
Would waive reading, have pleas of not guilty be entered. Ms. Howell would ask at this point in time for a court-appointed attorney. I would note to the court that per Michigan Indigent Defense Standards, Ms. Howell's last attorney was Attorney Todd Diedrich, but she would also like to address bond.
All right. Not guilty pleas will be entered on behalf of the defendant. Mr. Diedrich will be appointed to represent her. Is she waiving the right to have a hearing in 14 days, or does she want one set within 14 days?
Your Honor, we waive the right to have the hearing within 14 days, but ask that this matter be set for a status conference as soon as possible.
All right, will do. Bond was currently set in the older case at $1,000 cash, defendant's name only, and the newer case $1,500 cash only in defendant's name. So you may address bond.
Thank you, Your Honor. I've spoken with Ms. Howell. She indicates to me and would be requesting that this court set bond in the amount of $500 in each case. That would be to be posted in her own name. She has lived in Clare County her whole life. She indicates to me that she is looking currently on unemployment, but has many job opportunities in Bay City that she has been hoping to get. I would also note to the court that Ms. Howell indicates to me that her costs and fines in both of these cases are paid in full and have been for some time. I've never known Ms. Howell to not appear for court hearing when I have represented her, Your Honor.
Your Honor, may I address bond with regards to MDOC's position?
You may.
Ms. Howell's been on abscond status, obviously multiple warrants on multiple cases. It's my understanding through information I received from Agent Brubaker today that she's positive for methamphetamine and amphetamine and may be looking at new felony charges in an additional county at this time. We believe bond is appropriately set at this time and would actually ask for an increase of $1,500 cash in both cases.
The court will just leave bond as it is at this point. And we will see. Put it on the court's next motion day for a status conference at Mr. Diedrich's time. Anything further from any party?
Oh, Your Honor.
All right. You're all set, Ms. Howell.
Thank you.
Assistant Prosecutor.
In the case of People versus Allison Lorraine Matthews,
Yes, sir.
counsel identify for the record, please.
Yes, this is Allison Matthews.
Karen Tomczyk for Ms. Matthews.
Chief Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people. Your Honor, if I may just have 3 minutes. I'm in court on the record in district court via Zoom on another account. We're just short-staffed
All
and
right, go ahead, finish that one.
thank you, Your Honor, very much. I appreciate it.
Ms. Tomczyk, the court has been given a pretrial summary. Have you received a copy of that?
I have, Your Honor.
Court is signing the pretrial summary.
Your Honor, it is my understanding that Ms. Matthews does wish to take advantage of that offer at this time.
All right. How old are you, Ms. Matthews?
I am 31 years old.
Raise your right hand and be sworn.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ms. Matthews, have you received or gone over the information with your attorney?
Yes, sir, I have.
Ms. Tomczyk, is she waiving the right to have a reading of the information here today?
Yes, Your Honor.
And previously, she waived preliminary examination, is that correct?
Yes, Your Honor.
Looks like the plea offer is to plead to count 1 and 2 and dismiss count 3. Is that correct, Ms. Tomczyk?
Correct, Your Honor.
All right. Count 1 is police officer fleeing in the 4th degree. That is a felony that carries a maximum penalty of 2 years in prison and or a $500 fine. The Secretary of State shall suspend your license for 1 year. Count 2 is police officer assaulting or resisting or obstructing. A felony carries a maximum penalty of 2 years in prison and or a $2,000 fine. Consecutive sentence may be imposed if the assault was committed in a place of confinement. Otherwise, the minimum on both cases is discretionary with the court. Ms. Matthews, do you understand the charges and the possible penalties?
Yes, sir, I do.
There's one of 3 possible pleas that you may make to these charges. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand the one of 3 possible pleas you may make?
Yes, I do, Your Honor.
Answering to count 1, police officer fleeing in the 4th degree, how do you plead?
Guilty.
Answering to count 2, police officer assaulting, resisting, or obstructing, how do you plead?
Guilty.
You understand that no one may make any promises for this court as to what your sentence will be?
Yes, I understand.
All right. Well, I think we'll wait for the rest of it until Ms. Schwartz tunes back in. So, shouldn't only be another minute or 2.
Okay.
And Your Honor, just to, I would note to the court and Ms. Matthews that she does have another hearing in this court at 11 o'clock. I do not represent her on it. That is the PPO matter.
Yeah, and I think that was just like a status update thing. I don't know why Judge Borchard put it on since he handled the other hearing. I think it was just to make sure that everything was going okay.
Thank you, Your Honor. I appreciate your patience and holding off. Judge Farrell sends his appreciation to you for the delay.
Alright. I did proceed to get the waiving of the information reading, the waiving of the prelim. We got her pleas to counts 1 and 2. And now I'm at the point where I'm giving her her rights. All right?
Okay.
Okay. Continuing on, Ms. Matthews, if your plea is accepted, you will not have a trial of any kind and therefore give up the following rights. The right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent, not have that silence used against you during trial, and the right to testify at trial if you wish to do so and have your testimony considered in the same manner as any other person's testimony. Do you understand all these rights, Ms. Matthews?
Yes, Your Honor, I do.
You understand that by pleading guilty, you give up each and every one of those rights?
Yes, I do.
Ms. Schwartz, what is the plea agreement?
The plea agreement in this particular case, Your Honor, just one moment, I'm trying to pull up that file. I'm sorry for the delay. The computer is just running very slowly this morning.
Ms. Tomczyk, for the record, why don't you put on what the plea agreement is that you, your full and complete understanding is?
Yes, Your Honor. In exchange for Ms. Matthews to plead guilty to counts 1 and 2, count 3 would be dismissed. There is also a agreement pursuant to Briggs and Killebrew that Ms. Matthews would be sentenced at the bottom end of her the Department of Correction guidelines, Your Honor.
Schwartz, is that your recollection of what the plea offer was that compares to be complete with what's on this pretrial summary that was handled to the court?
Yes, Your Honor, and it is finally popped up on my screen. That is an accurate reflection of the agreement.
All right. Ms. Matthews, did you hear it was put on the record as the plea agreement?
Yes, sir, I did.
Did you understand it?
Yes, sir, I do.
And are you in agreement with it?
Yes, I am.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No,
Has anybody threatened you or your family in order to induce you to plead guilty?
not recently, no.
No. In this case, has anybody threatened you or your family in order to induce you to plead guilty in this case?
No,
Has anybody promised you that if you pled guilty, the court would be lenient upon you in any way?
no.
Is it your own personal choice to plead guilty?
Yes, it is.
And are you doing so freely and voluntarily?
Yes, sir.
Do you have any questions about what the court has told you?
Not at this time.
Have you understood everything that the court has told you?
To the best of my knowledge, yes.
Do you have any questions?
Not right now.
So you have understood everything that the court has told you at this point, is that correct?
Yes, sir.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes, I do.
Drawing your attention to on or about January 4th of 2021, were you in Lincoln Township, Clare County, Michigan?
I believe that's where this happened. I'm not 100% sure.
All right. Were you driving a motor vehicle?
Yes, I
at
was.
the time? Okay. And did a police car try to pull you over by putting its lights on or something?
Yes, I was pulled over.
All right. Did you fail to pull over immediately upon them
Your Honor?
signaling?
I
Yes?
did not.
Would you, I could list the factual basis if that would be easier.
All right, go ahead.
So Ms. Matthews, on that day and at that location, you were pulled over by a Deputy Huckstein.
Yes, that's correct.
Okay, and he was conducting a traffic stop at that point in time.
He had pulled me over for outdated insurance, is what he
Okay.
had stated.
All right, so he was conducting a traffic stop. That's correct,
Yes.
right?
Correct.
And during that traffic stop, you left that traffic stop prior to him stating that you could leave.
Correct. He said that he was going to be calling his supervisor, and I said if it was not an emergency, I was going to be leaving,
Okay,
and I did leave the scene.
And you did leave the scene, all right? Even after he told you you couldn't leave?
I don't recollect his exact words, but I left.
Okay. And he was not done with that traffic stop, though?
Not that I know of, no.
And so after you left, were you then approached by another Clare County Sheriff's vehicle?
About 10 or 15 minutes later, yeah.
Okay. And did you immediately stop for that vehicle?
I was actually already pulled over on the side of the road, and I was out of my vehicle, standing in the road, talking to some people walking on the side of the road.
Okay. So when you left the first stop, did Deputy Huckstein get back in his vehicle and follow you?
I didn't see that. I don't know.
Okay. And when you were arrested, did a deputy in full uniform give you instructions to stop resisting?
Yes, they gave me instructions to comply, and I repeatedly told them I was doing so and I was not resisting, and they put me in handcuffs.
Okay.
Did you refuse to let them put on the handcuffs at some point?
No, sir.
Did you in some way resist or obstruct or oppose the sheriff's deputy at anything? At any point?
Not at that time, no. I told them repeatedly I was complying and there was no resistance. I just wanted to know why I was being pulled over and why I was being arrested.
And at that point in time, you indicated to law enforcement officers that you were leaving because you believed that there was insufficient reason to be kept there?
I was still in handcuffs at that time, so I guess I wouldn't have been leaving, but I did say that I thought it was not protocol for the reasons that I was being obtained or detained.
And is that in fact why you left the scene where Mr. Deputy Huckstein was at?
That when I was originally pulled over by Officer Huckstein, like none of this had happened yet. So like there was no resistance there. There was no, I just told him that if there was no emergency that I had pressing issues actually at court that day and for my children. And that's when I drove away. And then about 10, 15 minutes later is then when I was approached again, but I was on the side of the road, this time out of my vehicle. And
so when you were telling the Deputy Huckstein you were going to drive away, did he tell you you should not do that or stop? Did he tell you stay here?
that I needed to wait for his supervisor.
I think you have enough there for assaulting, resisting, or obstructing for Deputy Huckstein, which if you want to amend the complaint, put that in. Otherwise, the court's not going to accept the pleas and we'll just go on and set another status conference date.
Okay,
Do you agree, Ms. Tomchuk?
Your Honor, I would not be opposed to an amendment on count 2 to remove Ashley Dawson and insert Robert Huckstein.
We
Is
would,
that what you wish, is
we
that what
would,
you wish to do, Ms. Schwartz?
we would move to amend that.
All right. So, Ms. Schwartz, you're satisfied with the factual basis for an amended count 2 and count 1, is that correct?
That's correct.
You're satisfied with the factual basis for count 1 and amended count 2, Ms. Tomchuk?
Yes, Your Honor.
Does the court comply with the court rules, Ms. Schwartz?
Yes, Your Honor.
Does the court comply with the court rules, Ms. Tomchuk?
It has, Your Honor.
Court has not agreed upon the possible plea or the possible sentence with either the prosecutor, defendant, or anyone acting in the interest of either. Court is convinced the plea is accurate and has been freely, voluntarily, understandably, and knowingly made. Plea is accepted and ordered entered upon the records of this court. Sentencing will be set for April 12th at 10 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Mr. Ween, any questions or information for Ms. Matthews?
Ms. Matthews, could I have your current address, please?
it is 5944 East Haskell Lake Road.
And your current telephone number?
Hang on one second. It is 989-273-8600.
Ms. Matthews, we're going to be sending you some packets in the mail that you need to fill out as soon as you get them, and then contact the agent that's listed on the packets. Reference your PSI interview, please.
Okay, absolutely.
Thank you.
Thank you very much.
Bond is continued. Case is adjourned to the date time set for sentencing.
Thank
And
you.
Your
All
Honor,
set, Ms. Matthews.
I would ask that the court leave her in the breakout room to attend that hearing at 11 o'clock. And then would also note to Ms. Matthews that we did discuss her bench warrant in the district court and that I am working to get her arraigned. So she needs to answer any phone calls from me.
Thank you very much. You.
All right. Push the TV back around. So it doesn't show me on the big screen,
Okay.
so I can see the people better.
Your Honor, if we could have a discussion on Mr. Weeks' case prior to going on the record.
All right. We'll go off the record right now. Did you need to meet with Mr. Weeks, or do you want to be in a breakout room with the prosecutor? Or do you
No,
want
Your
me
Honor.
involved?
We need you involved.
Okay. All right. I do have a pretrial summary in front of me. What do you wish to talk about, Ms. Tomchuk?
Your Honor, in this case, I have talked with prosecuting attorney Amber Zaitis, and she has no objection to this being a no contest plea. We would ask that if the court would accept the no contest plea on a delay of sentence.
Oh, that one's a tough one. Under the delayed statute, it says it has to be a guilty plea. I'm not sure I would want to do that.
If at that point in time, Your Honor, I guess let's go forward with the,
What we could do is something similar to a delay, where he pleads no contest, we put him on probation, and if he successfully completes the terms of probation, then you can get what was gonna happen. Was it gonna be reduced to a misdemeanor?
it was going to be dismissed, Your Honor.
Okay, and we could have the charges dismissed after successful completion of a probationary term.
I guess I would ask the prosecutor if they would be okay with that.
We have no objection to that. It's the no contest plea for civil liability purposes, I believe, is the issue. So we can guilty or no contest in the procedure that Judge Mink proposes.
Okay.
And then the court's gonna need something to read as a for the no contest facts.
We have drafted up an offer of proof. I can email that to the court.
Okay,
So I will send that along with, there's gonna be another no contest plea in another case. So I will send
Okay.
both offers of proof to the court. If the court would, place me in a breakout room with Mr. Weeks so I can explain, what's going on to him.
all right, court will take a short recess.
Michael?
Good.
That's okay. I'm not until 10:30. I don't think.
All right. 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
Make you seated. Calling the case of People versus Guy Garrett Weeks. Counsel identified for the record, please.
Morning, Your Honor. Chief Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people.
Karen Tomczyk appearing on behalf of Mr. Weeks.
You are Guy Garrett Weeks,
Yes, sir.
and how old are you?
I am 23.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Weeks, have you received a copy of the information or gone over the information with your attorney?
No, sir, but he fully explained it to me.
Mr. Weeks, yeah, that's the charging document that the court is asking you.
Oh, I'm sorry. Yep, I have went over it.
Ms. Tomczyk, is he waiving reading of the information for today's court?
Yes, Your Honor.
And previously waived preliminary examination, is that correct, Ms. Tomczyk?
Yes, Your Honor.
Mr. Weeks, you're being charged with count 1, assault with a dangerous weapon. That is a felony that carries a maximum penalty of 4 years in prison and or a $2,000 fine. DNA is to be taken upon arrest. Count 2 is weapons, firearms, possession under the influence. That is a misdemeanor that carries a maximum penalty of 93 days in jail and or $100 fine or $500 for using or discharging a firearm. Mandatory forfeiture of the weapon or device is required. Otherwise, the minimum is discretionary with the court in both cases or charges. You understand the charges and the possible penalties?
Yes, sir.
There's one of 4 possible pleas you may make to this charge, these charges. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty. You may stand mute, in which event the court will enter a plea of not guilty for you, or you may plead no contest, which means you will not contest the prosecutor's offer of proof, and it amounts to a plea of guilty. Do you understand the one of 4 possible pleas you may make?
Yes, sir.
Answering to count 1, assault with a dangerous weapon, how do you plead?
I plead no contest.
Answering to count 2, weapons, firearms, possession under the influence, how do you plead?
No contest.
Do you understand that no one may make any promises for this court as to what your sentence will be?
Yes, sir.
Court further informs you that if your pleas are accepted, you will not have a trial of any kind and therefore give up the following rights. The right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf ordered into court to testify at trial, the right to have this to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so and have your testimony considered in the same manner as any other person's testimony. You understand these rights?
Yes, Your Honor.
Understand by pleading no contest, you give up each and every one of those rights.
Yes, Your Honor.
The reason for the no contest plea?
Limit potential civil liability, Your Honor.
Court has reviewed the offer of proof. It does provide a factual basis for the charges. Does the court comply with the court rules, Ms. Schwartz?
Yes, it has, Your Honor.
Does the court comply with the court rules, Ms. Tomczyk?
Yes, Your Honor.
Court has not agreed upon the possible plea or the possible sentence with you, the prosecutor, or defendant, or anyone acting in the interest of either. Court is convinced the plea is accurate and has been freely, voluntarily, understandably, and knowingly made. Plea is accepted and ordered entered upon the records of this court. Sentencing will be set for April 12th at 10 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Bond is continued. Mr. Ween, any questions or information for Mr. Weeks?
Mr. Weeks, what's your current address?
It's 4851 Fresno Drive,
And your current telephone number?
989-621-1192.
Mr. Weeks, we're going to be sending you some packets in the mail regarding your PSI interview. You need to complete those as quickly as possible and then contact the agent that's listed on the packet for that interview.
Sir, can you send those to my mother's address? She lives directly behind me. I don't have a mailbox currently. It got knocked over by the plow.
What is that address then?
4850 Highland Court. And that's in Harrison, Michigan. Sorry
We'll
about
send
that.
That's all right. We'll send them there. Thank you.
Thank you.
Mr. Walt in the waiting room?
Mr. Weeks, you're all set. You can hang up.
Okay, thank you all. You have a nice day.
On the case of the People versus Dwayne Gary Walt Jr., counsel identified for the record.
Assistant Prosecuting
Yes.
Attorney Schwartz appearing on behalf of the people.
Karen Tomczyk appearing on behalf of Mr. Walt.
You are Dwayne Gary Walt Jr.,
Yes, sir.
and you're waiving the right to be present in the courtroom today for sentencing, is that correct?
Yes.
Previously, you appeared in court and pled to the charge. And the charges in file number 20-6373-FH of controlled substance, possession of a narcotic less than 25 grams, a felony that carries a maximum penalty of 4 years in prison. And count 2 in that case was, or second count that you pled to was operating with the presence of a controlled substance. That's a misdemeanor, carries a maximum penalty of 93 days in jail. Minimum is discretionary with the court in both cases. In file number 20-6481-FH, you pled to the charge of controlled substance, possession of methamphetamine. A felony carries a maximum penalty of 10 years in prison. Minimum is discretionary with the court. The controlled substance, less than 25 grams charge, sentencing guidelines were 0 to 11 months. On possession of methamphetamine, guidelines were 0 to 17 months. Ms. Tomczyk, have you had an opportunity to review that pre-sentence investigation report with your client?
Your Honor, I have. However, this was a case where an order for remand to recovery court was submitted to the prosecutor's office. I don't know if
It
that
hasn't
made it.
been through yet, but we're going to go through with sentencing today and sentence them to recovery court.
Okay, all
Okay?
right, thank you, Your Honor.
But I still need that order to sign to transfer it. All right. So you have reviewed the pre-sentence investigation report with your client, Ms. Tomczyk?
Yes, Your Honor.
Anything of a factual nature that you wish to add to, explain, or controvert?
No, Your Honor.
Any challenges to the guidelines?
No, Your Honor.
Ms. Schwartz, on behalf of the people, anything regarding the report?
We have no additions or corrections, Your Honor.
Any challenges to the guidelines?
No challenges, Your Honor.
Mr. Walt, do you have anything that you wish to say to the court before the court passes sentence?
Just that maybe this was a real wake-up call for me. I got into a real bad wreck here a few years ago, and I was real down and out for a long time. So I think this is going to be the best thing that could have happened to me. Best and worst, but mostly the best thing. I think I needed a real wake-up call and realize life is too precious. So that's really all I got to say, Judge. It's really all I got to say. Life is very precious, and I'm taking it for granted.
Ms. Tomczyk, on behalf of your client?
Yes, Your Honor. Mr. Wald has worked very hard during this period to try and maintain his sobriety. I think he is a good candidate for recovery court. He is very serious about his recovery, and I think he definitely does put it lightly. Not only was there a bad wreck, but he was also saved from his overdose using Narcan. And he indicates to me that it made him think about a lot of things that were going on, and the fact that, you know, he's realized that these individuals or so-called friends weren't there at that point in time. So he definitely wants to change his life and has been very active. It's my understanding that he has been attending AA and NA meetings when he can, and that he has also been attending recovery court sessions prior to his admission to make sure that, you know, he knows and is following up with what he needs to do for that.
Ms. Schwartz, on behalf of the people?
Your Honor, we just ask that you follow the agreement in this particular case. I received the documents for referral to recovery court this morning. I did print those and sign those documents. My understanding that Ms. Mercer from our office brought them up to the court, and they are waiting for the court in their mailbox. So if once you receive those, if you could sign those orders, Your Honor, for a referral to recovery court, I think that would be
We'll
great.
get those signed today.
Thank you so much.
All right. Court has reviewed through the pre-sentence investigation report, does provide for sentencing guidelines of 0 to 11 months and 0 to 17 months. In order to punish you for what you have done to attempt to rehabilitate you, deter others from committing similar acts in protection of the community, it'd be the sentence of this court that you be placed on probation in both cases for a period of 3 years, that you be ordered to attend the recovery court sessions. And Mr. Ween, when is the next recovery court session?
Next recovery court session, I believe, is next Thursday, Your Honor.
All right. So next Thursday. And we require them to be there at 9 o'clock, is that correct?
I believe court starts at 9 a.m. I would get here a little before that, though, just to make sure you're on time.
So you need to attend the next recovery court session, which will be March 4th at 9 a.m. Along with the statutory terms of probation and the terms of probation from the recovery court, which are going to be special terms that agent will go over with you on those. You must not use or possess alcoholic beverages or other intoxicants or enter any places that serve alcohol. You must comply with the requirements of alcohol testing as directed by the field agent. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must use prescription drugs only as prescribed for you by your licensed physician. You must attend AA, NA, or CA meetings at the frequency required by the field agent. You must complete outpatient or residential substance abuse treatment when referred by the field agent. You must complete a substance abuse assessment when referred by the field agent. You must complete mental health or other treatment, recommended treatment following assessment by a qualified community-based service provider. You must waive confidentiality and allow any treatment program that you are required to attend to disclose the information to your field agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have any verbal, written, electronic, or physical contact without permission of the field agent with anyone you know that have a felony record. You must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your placement on probation. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate the conditions of your probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must not have any verbal, written, electronic, or physical contact with William Kettner, either directly or through another person. You must make genuine efforts to find and maintain legitimate employment a minimum of 30 hours a week, unless engaged in an alternative program approved by the field agent. You must pay restitution in the amount of $235. You must comply with DNA testing, pay a $60 fee, pay a total of $186 in state costs. That's $68 for the 2 felonies. And I forget what it is, 56 for the misdemeanor charge, I'm not sure. So whatever that total is, whether it's 186 or something else.
Okay.
You must pay crime victims an amount assessment of $130 in each case file. You'll pay one supervision fee of $30 a month. Pay court costs of $500 in each file, fine of $500 in each file. How much are you charging for attorney fees?
Your Honor, I have it broken down by case.
Okay,
So case number ending in 6481, that would be $690. Case 6373, that would be $1,170.
okay. So those will be the attorney fees ordered in those cases.
Okay.
The court, you're gonna be required to do some community service as part of the recovery court. Court will allow reduction in fines and costs of $700 for the first 100 hours of community service completed. Probation officer of this court or any other supervising agent may, pursuant to MCL 771.4, apprehend, detain, confine a probationer who is in violation of a probation condition or who is conducting himself inconsistent with the public good. You're not allowed to use or possess recreational marijuana. You're not allowed to grow it. You must not possess, purchase, or attempt to purchase anything that contains ephedrine or pseudoephedrine without first obtaining permission from the field agent. You must set up an installment payment agreement with the Clare County Clerk's Office within 30 days for the payment of those fines and costs. And you must participate and successfully complete the Clare County Recovery Court program and abide by all the terms and conditions of that program and all its applicable fees.
Yes, Your Honor.
All right.
Yes, Your Honor. Yep.
You have the right to appellate review. If you're unable to forward your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the right of appellate attorney must be made in writing within 42 days, sent directly to the court. Mr. Ween, any questions or comments for Mr. Weeks? Mr. Walt?
No, just who do I contact?
Okay, Mr. Ween is going to talk to you, Mr. Walt.
Yes, sir.
Mr. Walt, you need to contact Agent Brubaker with the Clare County Probation Parole Office and Lisa Ashley with Recovery Court, please, as soon as possible.
Yeah. Yes, I stay in touch with Lisa on a regular basis, but yes, I will get a hold of Agent Brubaker immediately, or do I have till tomorrow? I'm out here at work.
By end of business today.
Oh, okay. Okay. I sure will. All right.
Thank you.
That's all the questions I have. Okay. All right. Thank you, Judge. I really appreciate it.
All right. Good luck to you.
Yes, sir. Yes, sir. All right. Are we done?
We're done.
Okay. Okay. All right. I just didn't know if I had to hang up. Okay.
I had 2 divorces that didn't go that slowly.
Mr. Guzman.
I'm just waiting for his. Okay, he just dropped it off. Thank you.
On the case of the People versus Justo Charles Guzman, counsel identify for the record, please.
Thank you, Your Honor. Chief Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people.
Your Honor, Karen Tomczyk, appearing on behalf of Mr. Guzman.
And you are Justo Charles Guzman?
Yes, Your Honor.
And how old are you?
27.
You raise your right hand and be sworn.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Well, Mr. Guzman, have you received a copy of the information or gone over that information with your attorney? Is that correct?
Yes, Your Honor.
Ms. Tomczyk, is he waiving reading of the information?
Yes, Your Honor.
And he previously held a preliminary examination, is that correct?
Correct, Your Honor.
Guzman, you're being charged with count 1, assault with a dangerous weapon. That is a felony that carries a maximum penalty of 4 years in prison and or a $2,000 fine. DNA is to be taken upon arrest. And you're being charged with count 2, domestic violence. That is a misdemeanor, carries a maximum penalty of 93 days in jail and or a $500 fine. The minimum in both regards is discretionary with the court. You understand the charges and the possible penalties, Mr. Guzman?
Yes, I do, Your Honor.
There's one of 4 possible pleas you may make to these charges. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you, or you may plead no contest, which means you will not contest the prosecutor's offer of proof, and it amounts to a plea of guilty. Do you understand the one of 4 possible pleas you may make?
Yes, Your Honor.
Answering to count 1, assault with a dangerous weapon. How do you plead?
No contest.
Answering to count 2, domestic violence. How do you plead?
No contest.
You understand that no one may make any promises for this court as to what your sentence will be.
Yes, Your Honor.
Court further informs you that if your pleas are accepted, you will not have a trial of any kind and therefore give up the following rights. The right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes, I do.
You understand by pleading no contest, you give up each and every one of those rights.
Yes, Your Honor.
The reason for the no contest plea, Ms. Tomchuk?
Claim of potential civil liability, Your Honor.
All right, that's an acceptable reason. Court has been presented an offer of proof. Court finds a factual basis for the pleas. Has the court complied with the court rules, Ms. Schwartz?
It has, Your Honor.
Has the court complied with the court rules, Ms. Tomchuk?
It has, Your Honor.
Court has not agreed upon the possible plea or the possible sentence with either the prosecutor, defendant, or anyone acting in the interest of either. Court is convinced the plea is accurate, has been freely, voluntarily, understandably, and knowingly made. Plea is accepted and ordered entered upon the records of this court. Sentencing is going to be set for April 12th at 10 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Bond is continued. Mr. Ween, any questions for Mr. Guzman or any information?
Mr. Guzman, what is your current address?
6845 East Gladwin Road, Harrison, Michigan, 48625.
And your current telephone number?
989-630-3853.
Mr. Guzman, we're going to be sending you some packets in the mail regarding your PSI interview. You need to complete them as soon as possible and contact the agent that is listed on the packet.
Okay.
All right, thank you.
Your Honor, I would also like to let Agent Ween know that a PSI was just recently done by a Brenda Leos out of Mount Pleasant, Isabella County.
All right.
Okay, thank you.
So do you want the sentencing moved up if that would speed things up, or?
No, Your Honor, that I don't. My understanding is that sentencing is supposed to occur next month. However, there may have been some delay. I know she was doing one, but she was still gathering some material, so that may be adjourned.
All right. Okay, we'll leave it on for the 12th then. You're all set, Mr. Guzman.
All right,
Today.
thank you, Your Honor.
You can hang up now, Mr. Guzman. Karen, is that the last of your cases?
No, she's got Wortella, or has that been adjourned?
That's been reading.
Remanded, okay.
Yeah, I was
We're
gonna
done.
say, all right.
Yeah.
I didn't know if we got the message to Mr. Wartella, so I didn't know if he was in the waiting room or not.
Unless he's under a different name. Let me see for you. Hold on one second.
We'll take a short recess.
All right.
Hey, Alicia or Karen,
Yep.
what was the plea?
All right. 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
You may be seated. In the case of People versus Stephen William Hovey, counsel identify for the record, please.
Morning, Your Honor, Chief Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people.
Please, the court, Scott Moore for the defense.
You are Stephen William Hovey,
I am.
and you're waiving the right to be present in the courtroom for sentencing, is that correct?
That is.
Previously, you appeared in court and pled to police officer assaulting or resisting or obstructing, a felony. It carries a maximum penalty of 2 years in prison. And you also pled to the charge of child abuse in the 4th degree. A misdemeanor carries a maximum penalty of 1 year in jail. Sentencing guidelines were determined to be 0 to 17 months on the felony charge. A pre-sentence investigation report has been prepared. Mr. Moore, have you had an opportunity to review that pre-sentence investigation report with your client?
Yes, Your Honor.
Anything of a factual nature that you wish to add to explain the controversy?
No, Your Honor.
Any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Schwartz, on behalf of the people,
Your Honor, I have you review the pre-sentence investigation report, have no additions or corrections, nor any challenges to the scoring.
Mr. Hovey, is there anything you wish to say to the court before the court passes sentence?
Not at this time.
Mr. Moore, on behalf of your client?
Thank you, Your Honor. This is one of those cases that is regrettable for how it transpired. In the sense that Catherine Lumbert and Stephen Hovey are the parents of the child. They're young people. There was a situation, for lack of a better term, going on. Law enforcement acted appropriately in that they were concerned for the safety of everyone and responded accordingly. Mr. Hovey acted in the heat of the moment. Unfortunately, no one was injured. And while I will concede that by the strictest reading of the jury instructions on child abuse fourth, he is certainly guilty of that. However, we're talking about the reasonable likelihood that injury could have occurred. There is a dispute factually among the parties about whether the child was set more gently than not, but in any event that happened, the charges were filed and here we are. In the meantime, Mr. Hovey has cooperated with the Isabella County Department of Health and Human Services in their ongoing case down there. We have asked that the bond condition preventing contact with his child be modified to allow for that contact with the child with adult supervision, particularly Catherine Lumbert.
Has the health department lifted that no contact order?
Yes, sir. Yes, there's been no adverse action from Isabella County on that. So with that in mind, the fact that my client is currently under supervision to the Isabella County Trial Court, we believe that the sentencing guidelines of 0 to 17 months and a 2-year offense suggest a community sanction. I know that Agent McConnell was recommending the full 12 months. That was the cap that we agreed to. It was not exactly a full-throated argument for that. And I do note that in the order section to be filled out by your honor. That is blank. I'm asking the court to consider awarding time served for what's been done to allow my client to continue his efforts of his parenting classes and other rehabilitation, and also the Isabella County oversight. Thank you, Your Honor.
Ms. Schwartz, on behalf of the people?
Thank you, Your Honor. I don't have any objection speaking directly to the no contact order issue, so long as it's with supervision by an adult, that the defendant comply with all of the requirements of the Michigan Department of Health and Human Services Parent Agency Agreement and Treatment Plan. I would leave it to Ms. Lumbert, who I believe has appeared today, to speak for herself in regards to the no contact order. I ask that you follow the agreement in this case. I do see that upon reviewing the pre-sentence investigation report, the oversight fees were left blank on my copy, and I don't know if that was just a copying error, but I would ask for the standard oversight fees to be included in your sentence today, Your Honor.
Are there any victims present that wish to speak to the issue of sentencing?
Yes,
Ms.
I would like
Lumbert?
to speak.
All right, you are Catherine Lumbert?
Yes,
Okay, go ahead.
yes, I am. I would just like to ask that there be no contact order not put back on. I'd still like to have Stephen around and be able to see myself and our son. I'm currently 5 months pregnant with our second boy. You know, things are going really, really well. I just want to give my voice to the court saying that I believe everything is going extremely well for us right now. I just recently left my previous job due to an issue with possible COVID at work. So I'm only doing Uber Eats right now. Stephen is the primary income for the household. And, you know, he does a wonderful, wonderful job working hard for us. Yeah, we love having him around. Jack is absolutely his best friend for sure. Yeah, I ask that there be no jail time, that the no contact order stays removed, and, you know, we're able to get our families continuing at where we're going.
Your Honor, in that connection, I would draw the court's attention to the Department of Corrections recommendation, paragraph 1. That recommendation, I think, is the only no contact in here. And I would ask the court to address that when the sentence is pronounced. Thank you.
As part of the Department of Health and Human Services program, has he been doing some domestic violence or anger management counseling?
Yes, Your Honor.
Court has reviewed through the pre-sentence investigation report, does provide for sentencing guidelines of 0 to 17 months. In order to punish you for what you have done, to attempts to rehabilitate you, deter others from committing similar acts, protection of the community, be the sentence of this court, that you be placed on probation for a period of 2 years. Along with the statutory terms of probation, have the following special conditions. You must not have a verbal, written, electronic, or physical contact with any individual age 17 or under, unless it is your child only at this point. That can be removed if we get something from the Department of Health and Services that has no objection to it. You must not use or possess alcoholic beverages or other intoxicants or enter any places that serve alcohol. You must comply with the requirements of alcohol testing as directed by the field agent. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must use prescription drugs only as prescribed for you by your licensed physician. You must complete outpatient or residential substance abuse treatment when referred by the field agent. You must complete a substance abuse assessment when referred by the field agent. You must take your medications as prescribed by a licensed physician. You must complete mental health or other domestic violence or other recommended treatment following assessment by a qualified community-based service provider. You must waive confidentiality and allow any treatment program that you are required to attend to disclose information to your field agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have any verbal, written, electronic, or physical contact without permission of the field agent with anyone you know that have a felony record. You must not change your residence unless you first obtained written permission from the field agent. You must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your placement on probation. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate conditions of probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends, and holidays accepted. You must notify the field agent of service of any personal protection order upon you within 24 hours of that service, weekends, and holidays accepted. You must be in your approved residence between the hours of 12 a.m. and 6 a.m. unless excused by first obtaining written permission from the field agent. You must pay $118 in state costs, $130 crime victims fee. Is he currently on probation in Isabella County?
Yes, sir.
The felony probation?
I believe so. Is that correct, Mr. Hovey?
I believe it's a district court matter.
All right.
Thank you.
Court's gonna order that you pay a $30 a month supervision fee. Court costs of $500, a fine of $500. How much are you charging for attorney fees?
$450, Your Honor.
$450 in attorney fees. Court's gonna order you to do 40 hours of community service. Probation officer of this court or any other supervising agent may pursuant to MCL 771.4 apprehend, detain, confine a probationer who is in violation of probation condition or who is conducting himself inconsistent with the public good. Must not possess, purchase, or attempt to purchase anything that contains ephedrine or pseudoephedrine without first obtaining written permission from your field agent. You're not allowed to possess or use recreational marijuana or grow recreational marijuana. You must set up an installment payment plan with the Clark County Clerk's Office within 30 days for the payment of the fines and costs. No contact order in this case with the victim is dismissed. You are entitled to appellate review of your conviction and sentence. If you're unable to hire your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of appellate attorney must be made in writing within 42 days sent directly to the court. Please sign the notice of appellate rights form. Bond is canceled. Mr. Wing, you have any questions or information from Mr. Hovey?
Mr. Hovey, an agent will be in contact with you. Can I get a current telephone number?
989-820-2184.
Okay.
Good luck to you, Mr. Hovey.
Thank you, sir.
You are both all set if you want to hang up now.
Thank you.
Alicia, do you know who it was from Mount Pleasant?
I do not.
Okay. And is it for Danny Worth?
Oh, that might be.
Her mom,
She's
her
not
mom's
showing.
already in and labeled as such.
Okay. All right, I'm gonna bring in a Katie Eberhardt, because I don't know who it is.
She's from DHHS and she's here on Mr. Matthews' case.
Mr. Matthews. Hang on, and I will turn it on.
She won't be providing any testimony, she's just monitoring.
Okay, then I'll move her back. Thank you. She is from Mr. Matthews?
Matthews, that's correct.
Okay.
In the case of People versus Danny, Supreme Work. Lyra Work.
Prosecuting attorney Alicia Schwartz appearing on behalf of the people.
And please, the court, Scott Moore for the defense.
And you are Danny Worth? He's on mute.
Ms. Worth, can you unmute your computer, please?
Okay, now can you hear me?
Yes, ma'am.
Okay, sorry, it kept defaulting back to something. Anyway,
And we have the victim also here.
That is correct, Your Honor.
She want to unmute and identify herself?
Miss
All
I,
right.
please unmute yourself for the court and identify yourself by your name.
Okay, can you hear me now?
Yes.
Okay, my name is Susan Eisler and I am Danny's mom.
All right. Ms. Worth, previously you appeared in court and pled to the charge of home invasion in the 3rd degree. That's a felony. It carries a maximum penalty of 5 years in prison. Minimum is discretionary with the court. Pre-sentence investigation report has been prepared. Sentencing guidelines have been determined to be 0 to 9 months. Mr. Moore, have you had an opportunity to review that pre-sentence investigation report with your client?
Yes, Your Honor.
Is there anything of a factual nature that you wish to add to explain or controvert in that report?
Only to this extent, Your Honor. The report was written in December of 2020. I did speak with Agent Brubaker yesterday. There were no substantive changes. While she is speaking, the hope that Ms. Worth would get into a shelter, she has gotten into a shelter, and she remains there, still looking for other housing. Other than that, we have no objection.
Any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Schwartz, on behalf of the people, anything regarding the report or the guidelines?
I know, Your Honor. No additions or objections.
All right. Ms. Worth, is there anything you wish to say to the court before the court passes sentence?
actually, back in December, I came here to the shelter to get out of jail ultimately. I have since then, maintained a full-time job. Go to AA or Zoom meetings when I can, have applied for housing. I'm just waiting for basically things to open up. I have CMH, mental health counseling. So I have a therapist there. They just switched me to a different one. And so I'm just, still keeping on. So I guess this is a blessing in disguise. That's all I got to say.
Mr. Moore, on behalf of your client.
Thank you, Your Honor. I believe that my client has eloquently covered the high points. There is an agreement in this case for this matter to be reduced to a misdemeanor upon successful completion of a delay of sentence. The department is recommending that delayed status be granted, and I would ask the court to adopt that recommendation. Thank you.
Ms. Schwartz, on behalf of the people.
Your Honor, we do ask that you follow the agreement in this particular case. I believe that the victim in this case does have a statement that she would like to share with you at this time.
Ms. Eisler, is there anything you wish to say regarding sentencing?
Absolutely, Your Honor. For one thing, I don't even understand what the home invasion is because she did never enter and break into my home, so I'm confused about that. But my main concern is that she gets all the help that she needs for her mental stability, not just throwing her by the wayside, because she is a very smart, understanding girl, and she has a lot to offer. And I guess I don't understand how the breaking and entering, I never even knew that was a charge until probably a month ago. And I don't understand it, I guess is what I'm saying. She never did break and enter in my home, so. But again, I want her to get all of the help that she could possibly need, that you could possibly give her. Like I say, she's a very intelligent girl and she has a lot to offer.
Court has reviewed through the pre-sentence investigation report does provide for sentencing guidelines of 0 to 9 months. This is an agreement for a delay of sentence. The court finds it appropriate in this case. In order to punish you for what you've done, to attempts to rehabilitate you, deter others from committing similar acts, and protection of the community, we're going to put you on a 1-day delay of sentence, along with the.
I'm sorry, Your Honor, was that 1 day?
1 year.
Thank you.
My mistake there. 1 day would be pretty short.
Yes, Your Honor.
Yes, that'd be great.
1 year delay of sentence, and the usual terms for probation will apply, along with these special terms. You must not use or possess alcoholic beverages or other intoxicants or enter any places that serve alcohol. You must comply with the requirements of alcohol testing as directed by the field agent. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know possess these items. You must use prescription drugs only as prescribed for you by your licensed physician. You must complete outpatient or residential substance abuse treatment when referred by the field agent. You must complete a substance abuse assessment when referred by the field agent. You must take your medication only as prescribed by the licensed physician. You may perform 100 hours of community service as directed by the field agent. If you successfully complete 100 hours, the court will reduce your fines and costs by $700. You must complete a psychological evaluation when referred by the field agent. You must complete mental health or other recommended treatment following assessment by a qualified community-based service provider. You must waive confidentiality and allow any treatment program that you are required to attend to disclose information to your field agent. You must comply with the Michigan Department of Corrections electronic monitoring program and or remote alcohol monitoring when referred by the field agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have any verbal, written, electronic, or physical contact without permission of the field agent with anyone you know to have a felony record. You must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your placement on delay of sentence. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate your conditions of probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must notify the field agent of service of any personal protection order upon you within 24 hours of that service, weekends and holidays accepted. Ms. Eisler, do you still want the no contact order to continue?
No.
All right.
Your Honor, I do want to take the opportunity to let my client know that there are still matters pending in district court. I believe there are no contact orders there. So until that's resolved, thank you.
Okay.
Thank you.
Must make genuine efforts to find and maintain legitimate employment, minimum of 30 hours a week. Must comply with DNA testing, pay a $60 fee, pay a $68 state cost, pay a crime victim's assessment of $130. Pay a supervision fee of $30 a month. Pay court costs of $500, a fine of $500, and how much are you charging for attorney fees in this case?
$270, Your Honor.
$270 in the court appointed attorney fees. The probation officer of this court or any other supervising agent may pursuant to MCL 771.4 apprehend, detain, confine a probationer who is in violation of a probation condition or who is conducting herself inconsistent with the public good. You're not allowed to use or possess or grow recreational marijuana. You must not purchase or possess or attempt to purchase anything that contains ephedrine or pseudoephedrine without first obtaining permission from the field agent. You must set up an installment payment agreement with Clark County Clerk's Office within 30 days. Is there any restitution requested?
None that I know of, Your Honor.
Court's not going to order any restitution at this time, but if a request for restitution comes in, it will be ordered. If you do everything you're told, Ms. Worth, and continue on the good track that you seem to be on, good things happen. This conviction will go away. So continue to do what's required of you.
Thank you, Your Honor.
Mr. Ween, any questions for Ms. Worth?
Ms. Worth, you have to contact Agent Brubaker within 24 hours after sentence, please.
Yes, I will. Thank you.
Thank you.
Good luck to you, Ms. Worth.
Thank you. Bye,
You're all
Mom.
set. They didn't order it. But she's got it apparently in other cases.
You're all set, ladies. You can hang up.
Is that offer of proof sufficient?
It would have been nicer if you referred to.
Good morning.
some
Are you
pages
James
in the
Matthews?
opinion.
Well, that's why I stick it
That-
up.
I see you see that.
Yeah.
I just need to unmute your computer.
Yeah, I'm
Can you
James.
hear the court?
Yes, ma'am.
Thank you.
Okay. I didn't think she would stay on. On the case of the people versus James Ignatius Matthews, counsel identify for the record, please.
Assistant Prosecuting Attorney Alicia Schwartz appearing on behalf of the people.
Please, the court's got more for the defense.
You are James Ignatius Matthews.
Yes, sir.
How old are you?
45.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And Mr. Matthews, have you received a copy of the information and gone over that information with your attorney? Is that correct?
I did not receive a copy, but I went over it with him.
All right. And Mr. Moore, is he waiving reading of the information for today's purposes?
Yes, Your Honor. Waive reading, preliminary examination.
All right. Agreement that he's going to plead no contest to?
Thank you, Your Honor. It's my understanding we will be proceeding on count 2 of the information. The agreement is, I'll leave that to the
All right.
Thank you.
Mr. Matthews is being charged with count 2, assault with a dangerous weapon. That's a felony that carries a maximum penalty of 4 years in prison and or a $2,000 fine. DNA is to be taken upon an arrest. Otherwise, the minimum is discretionary of the court. You understand the charge and the possible penalties?
Yes, sir.
There's one of 4 pleas that you may make to this charge. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you, or you may plead no contest, which means you will not contest the prosecutor's offer of proof, and it amounts to a plea of guilty. You understand the one of 4 possible pleas you may make.
Yes.
Answering the count 2, assault with a dangerous weapon, how do you plead?
No contest?
You understand that no one may make any promises for this court as to what your sentence will be.
They told me it was.
That means that if there is a plea agreement with a cap on the sentencing of some type, if the court decides not to go along with that, then you'll be able to withdraw your plea. You understand that?
Yes, sir.
All right. Court further informs you that if your plea is accepted, you will give up the following rights: the right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so, and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes, sir.
You understand by pleading no contest, you give up each and every one of those rights.
Yes, sir.
Ms. Schwartz, what is the plea agreement?
Your Honor, the plea agreement in this particular case is that he would enter a guilty or no contest plea to count 2, and that there be a 12-month period in which, if he's successful, that charge would be reduced to a domestic violence offense. We would be dismissing the remainder and the habitual offender 4th notice. There is also a Briggs-Killebrew agreement of no initial incarceration in this case. It was initially, the language stated a delay of sentence, but I know Your Honor dealt with the delay and no contest pleas earlier today with Ms. Pavchek, and were able to facilitate the spirit of that agreement with setting aside the plea and entry of a different charge at the conclusion of probation if successful.
All right, statutorily, the delay of sentence has to be a guilty plea, so. Mr. Moore, is that your full and complete understanding of the plea agreement?
It is, Your Honor. I was not aware of the court's position on the statute. I'm not stating this merely for the
It
record.
accomplishes the same thing by doing the
It certainly
probation
does.
and setting aside with the successful completion.
All I wanted to say was in this building, there are other judges who take a different reading of that law.
I'm sure.
Had I known the court's position, we would have crafted this in line with that. Thank you.
All right, no problem. Mr. Matthews, did you hear what was put on the record as the plea agreement?
Yes, sir.
Did you understand it?
Yes, sir.
And are you in agreement with it?
Yes, sir.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead no contest?
No, sir.
Has anybody threatened you or your family in order to induce you to plead no contest?
No, sir.
Is it your own, has anybody promised you that if you pled no contest, this court would be lenient upon you in any way?
No, sir.
Is it your own personal choice to plead no contest?
Yes, sir.
And are you doing so freely and voluntarily?
Yes, sir.
Do you have any questions about what the court has told you?
No, sir.
Have you understood everything that the court has told you?
Yes, sir.
In light of everything that the court has told you, do you still wish to plead no contest?
Yes, sir.
Court has been drafted, given an offer of proof. Court has reviewed pertinent parts of the preliminary examination that gives a factual basis for the charge. Ms. Schwartz, has the court complied with the court rules?
Court has.
Mr. Moore, has the court complied with the court rules?
It has, Your Honor. As we stated in the offer of proof, we are seeking entry of the contest plea to minimize defendant's exposure to civil liability.
That was my next question.
I'm so sorry.
No problem.
Okay.
Court has not agreed upon the possible plea or the possible sentence with either the prosecutor, defendant, or anyone acting in the interest of either. Court is convinced the plea is accurate, has been freely, voluntarily, understandably, and knowingly made. Plea is accepted in order to enter upon the records of this court. Sentencing will be set for April 12th.
May I address Bonder?
You may.
I'm sorry, April 12th for sentencing.
Yeah.
And,
At 8:45 a.m.
Very good, Your Honor.
Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Anything regarding bond, Mr. Moore?
Thank you, Your Honor. In light of the plea agreement and the fact that my client has been incarcerated for since the date of arrest, more than 6 months, we're not quite up to the 180 days, but very close. In order to facilitate the parent agency treatment plan that's been ordered by the presiding judge of the Family Division of Circuit Court, and that includes but not limited to secure independent housing, work with CMH intake, and as Your Honor might recall, back in 2020, we were seeking an intake to be done by CMH. They declined to do that because of my client's incarceration, psychological exam, as well as getting employment. All of those things will help his children, help his case there, and we would ask the court to modify bond to personal recognizance in any amount pending sentencing. Thank you.
All right. Any objection, Ms. Schwartz?
None, Your Honor.
I guess my only question is, does he have a place that he can reside?
And I did want to address that, Your Honor. Thank you for reminding me. Right now, the current no contact order with Allison Matthews, the victim in this case, we're not asking that that be lifted. However, there is a residential prohibition, so he can't go onto the property, which is owned as by tenants in the entirety. My understanding, although it's not been independently confirmed, is that she's moved out of that residence. So I would ask the court to consider lifting the prohibition on going onto the property, but leaving the no contact with the victim in place.
And Mrs. Matthews, you're not online anymore, is that correct? Don't have her? Okay.
She is scheduled for hearing after this on the PPL.
Yeah, I don't know if she's gonna call in though, because she was already online earlier.
Oh, she was?
Yes.
The reason why I asked Ms. Eberhardt to be here today is she will help Mr. Matthews facilitate finding housing if he is unable to return to the home.
Right. What's her name again?
Katie Eberhardt.
All right, Ms. Eberhardt, you're from the Department of Health and Human Services?
Yes, good morning, Your Honor, I am.
And you're working with both Mr. and Mrs. Matthews?
Correct, I am the foster care worker for this case.
All right, and do you know whether Mrs. Matthews is still residing in the marital home?
Your Honor, I'm honestly not entirely sure where Miss Matthews would identify her permanent residence as. We have not facilitated meetings at that residence though. So I'm not under the impression that she does reside there full time. When I was attempting to locate her after she was released from jail, I made several attempts at that address to locate her and I never made contact with her there.
All right, court will reduce the bond to a PR bond, change the bond to a PR bond. You're still, if there's any evidence that Ms. Matthews is still residing at the marital home, then you're not to go there. All right, Mr. Matthews?
Yes, sir.
If you go there and she comes there, you better leave, okay?
Your Honor,
Yes,
just as a point of clarification, Ms. Matthews indicated earlier that same residence as to where we should send the packets, to 5944. So if she's not residing there, I'm not
that's
sure
where
if she's going
she's
to get
getting her
those.
mail. That's at least where she's getting her mail, so she's going there to get her mail, at the very least.
At the very least,
Well,
yeah.
I would suggest, Mr. Matthews, that you find someplace, other place to live and avoid going to that residence until this is cleared up later on.
Yeah, okay.
Otherwise you're gonna put yourself at jeopardy of being arrested for violation of the PPO because the PPO is still in effect. All right?
I thought there was a hearing for that.
Well, the other judge put it on, I don't know why, because he had the hearing and he denied your motion to terminate, and he just set it on for today. I think he set it on just in case some things got resolved between the parties, but apparently nothing is resolved between the parties. So we're not having another hearing. I tried to address that with Mrs. Matthews earlier, but didn't really get any response on that. And everybody referred that it was on, rescheduled for 11 o'clock. It was put on earlier. And so now she's not appeared at 11 o'clock, so there's no way to discuss anything with her about it.
Okay.
All right?
Yeah.
You're all set. I don't know, Mr. Ween, any further questions?
Mr. Matthews, we're going to be bringing you some packets that you need to fill out regarding that PSI interview. There'll be a notation on there to contact an agent regarding that interview. Once those are completed, you need to contact that agent.
Mr. Ween, if you
Do I
could-
take it with me or what do I do?
Yes, we're going to bring you the packets. You're going to take those with you when you leave jail.
And then, Mr. Matthews, contact my office and we'll assist you in completing that. And Mr. Ween, if you could let the report writer know that I'd like to be part of the interview.
Okay.
Thank you.
All right, you're all set, Mr. Matthews.
Thank you.
Ms. Eberhardt, you can sign off also.
Thank you, Katie.
Thank you, Your Honor.
On this job for gratitude, I need to find another line of work.
The gratitude is in your knowing of what the result is and what it could have been.
Yeah. I reward
Mine
them.
is Romanstein. Watch.
Is he next? You on next?
Yeah. Thank you.
The corrections, can we get the rolling time in place of Matthews, please?
Blank screen. There it is. Good morning, Todd.
Morning, how are you?
Good. We are just waiting for Mr. Stein.
Okay.
You wouldn't have me hit the delete button because I'm not delete him.
but I do have the other room. I just don't know where they're gonna bring him.
Correction is, if you bring sign, probably come.
I think it's,
So Matthew's got PR bond on his criminal stuff or on his?
On this criminal case. But
He's still not.
if he's got other cases, then yeah, he's stuck.
Judge, are we set for the current felony and the probation violation?
Yes.
All right, thank you.
Here we go.
No resolution.
okay. Thank you.
Do we have a prosecutor?
Well, we had one. Mr. Stein, are you good to go? We talked yesterday. Do you need to see me in private at all?
No, I'm good. Thank you.
Calling the cases, the People versus Roland Andrew Stein. Counsel identify for the record.
This is the prosecuting attorney, Alicia Schwartz, appearing on behalf of the people.
Thank you, Your Honor. Todd Diedrich appearing on behalf of Mr. Roland Stein.
And we're set on file number 20-6374-FH as a final pretrial. The trial was scheduled for March 24th, but that is going to be adjourned, so we won't be having that trial. We're not ready to have a trial yet. And the other case, 19-6177-FH, was a continuation of a probation violation case. Has there been any resolution to these cases, Mr. D?
There have, Your Honor. We're prepared to do no contest pleas in both files.
All right. And what is the plea going to be in 20-6374-FH?
Mr.
What
Stein,
charge?
possession of methamphetamine as a second or subsequent drug offender.
Okay. And which charges is he going? He's not going to plead to all counts in the probation violation. So I
Counts
don't want him to.
Probation recommended 1, 3, and 7.
All right. And has there been an offer of proof drafted up, or you want me just to review the preliminary exam for factual basis?
If you don't mind, Your Honor, we just got this finally resolved yesterday, and we did not have opportunity to prepare anything.
All right, I'll just review the preliminary exam. I'm sure there's enough information there for a factual basis. And then you can reduce it to an offer of proof later on.
All right.
Mr. Stein, how old are you?
34.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
And file number 20-6374-FH, Mr. Stein, you've received a copy of that information, or you've gone over that information with your attorney, is that correct?
Yes, Your Honor.
And Mr. Diedrich, is he waiving a reading of the information?
He is, Your Honor.
And preliminary examination was already had in that file. And you're being charged with count 1, controlled substance, possession of methamphetamine, second or subsequent offense. That's a felony. It carries a maximum penalty of 20 years in prison and or a $30,000 fine, unless sentenced to more than 1 year prison, the court shall impose license sanctions. Otherwise, the minimum is discretionary with the court. And file number 19-6177-FH. You're currently on probation for controlled substance possession of methamphetamine. A felony carries a maximum penalty of 10 years in prison. Minimum is discretionary with the court. Count 1 is violation of Rule 3. Count 3 is violation of Rule 1. And count 7 is violation of Rule 13, Special Condition 2.4. There's one of 4 possible pleas that you may make to these charges, Mr. Stein. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you, or you may plead no contest, which means you will not contest the prosecutor or the probation department's offer of proof, and it amounts to a plea of guilty. You understand the one of 4 possible pleas you may make, Mr. Stein?
Yes, Your Honor.
Answering in file number 20-6334-FH to count 1, controlled substance possession of methamphetamine, second or subsequent offense. How do you plead?
No contest.
Answering in file number 19-6177-FH to count 1, violation of Rule 3. How do you plead?
No contest.
Answering to count 3, violation of Rule 1. How do you plead?
No contest, Your Honor.
And answering to count 7, violation of Rule 13, Special Condition 2.4. How do you plead?
No contest, Your Honor.
All right. You understand that no one may make any promises for this court as to what your sentence will be?
Yes, Your Honor.
Court further informs you that if your pleas are accepted, you will, in the new case, you will not have a trial of any kind and therefore give up the following rights: the right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf in the court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so and have your testimony considered in the same manner as any other person's testimony. You understand these trial rights?
I do, Your Honor.
You understand by pleading no contest, you give up each and every one of those rights?
Yes, Your Honor.
Addressing file number 19-6177-FH. If your pleas are accepted, you will not have a hearing of any kind and therefore give up the following rights: the right to have a contested revocation hearing, the right to be represented by an attorney, the right to a court-appointed attorney if you're unable to afford one. Mr. Deduk is representing you on this matter that the maximum possible sentence could be 10 years in prison. The minimum is discretionary with the court. That you give up the right to appear at a hearing, present evidence, cross-examine witnesses, give up the right to have the prosecution or probation office establish a violation by a preponderance of the evidence. Give up the right to remain silent and not have that silence used against you during the hearing, and you give up the right to testify at the hearing if you wish to do so, and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes, Your Honor.
Do you understand by pleading no contest, you give up each and every one of those rights?
Yes, Your Honor.
What is the plea agreement?
Like me to put that on the record, Ms. Schwartz, or do you want to?
Go ahead and do that, please.
Thank you. Your Honor, in exchange for Mr. Stein's no contest plea in the 2020 file, there's an agreement to a stipulated sentence of 12 months in the Clare County Jail. And same goes for the 2019 file in exchange for Mr. Stein's no contest plea to count 1, 3, and 7. There's an agreement, well, there's a recommendation for 12 months in the Clare County Jail, and the remaining counts would be dismissed.
Ms. Schwartz, that's your understanding of the plea agreement?
That's my understanding of the agreement based upon the information in our paperless system.
And Mr. Wayne, that's your understanding for the probation file also?
On the probation matter, Your Honor, I was notified that it is to run concurrently with the new felony case, and an unsuccessful discharge from probation will be requested as well.
Is that your understanding also, Mr. Diedrich?
I apologize. Yes, that was also on the paper. It was, yes.
Mr. Stein, did you hear it was put on the record as the plea agreements?
Yes, Your Honor.
Did you understand them?
Yes, Your Honor.
And are you in agreement with them?
Yes, Your Honor.
Has anybody promised you anything beyond what was stated in the plea agreements to induce you to plead no contest?
No, Your Honor.
Has anybody threatened you or your family in order to induce you to plead no contest?
No, Your Honor.
Has anybody promised you that if you pled no contest, this court would be lenient upon you in any way?
No, Your Honor.
Is it your own personal choice to plead no contest?
Yes, Your Honor.
And are you doing so freely and voluntarily?
Yes, Your Honor.
Do you have any questions about what the court has told you?
No, Your Honor.
Have you understood everything that the court has told you?
Yes, Your Honor.
In light of everything the court has told you, do you still wish to plead no contest?
Yes, Your Honor.
And the reason for the no contest, please, Mr. Diedrich?
Your Honor, I believe limitation of civil liability would be appropriate in this particular case. Page 52 might be helpful, Your Honor. Is a summation. The summation by the district court, reading of the testimony. The last paragraph or second to last paragraph, yeah.
Okay. That'll help. Court finds a factual basis for the pleas. Has the court complied with the court rules, Ms. Schwartz?
It has, Your Honor.
Has the court complied with the court rules, Mr. Diedrich?
Yes, Your Honor.
Court has not agreed upon the possible plea or the possible sentence with either the prosecutor, defendant, or anyone acting in the interest of either. Court is convinced that the plea is accurate, has been freely, voluntarily, understandingly made. Pleas are accepted in order to upon the records of this court. Sentencing will be set for April 12th at 9:40 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Factual basis for the probation file is from a updated case report and partially from the preliminary exam transcript. Case is adjourned to the date time set for sentencing. Anything further, anybody?
No, Your Honor, thank you.
All right,
Thank you, Your Honor.
we're in recess.
All right.
Date on the sentencing?
It's April 12th,
Thank you.
9:40 a.m.
Hey Peggy, is that everything for today?
For you, yes,
And we still have court at 8:30 tomorrow morning?
correct.
Okay, thank you. We'll see you then.
Thanks, Eric.
All rise. 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
You may be seated. Calling the case of Laura Marie Maselli versus Michael Stephen Summers. Counsel identified for the record, please.
Good afternoon, Your Honor. May it please the court, Eric Miles on behalf of Laura Maselli.
Good afternoon, Your Honor. Joseph Duso on behalf of the defendant, Michael Summers.
And you are Laura Maselli?
I am.
And you are Michael Summers?
I am.
All right. And Mr. Duso, it's your motion, so you may proceed.
If it's all right with the court, I'd just like to get right into testimony with calling my client, Michael Summers.
All right, Mr. Summers, would you raise your right hand and be sworn?
Do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
You may proceed.
Thank you. Mr. Summers, can you state your full name and spell your last name for the record?
Michael Summers, S-O-M-E-R-S.
And Mr. Summers, how old are you?
48.
And can you tell the court where you are currently employed?
I'm employed in North Dakota on a family farm.
And is this a small farm, large? Is this a commercial operation or just a hobby farm?
No, it's a commercial farm, 30,000 acres.
And how long have you been employed there?
I started August 1st of 2018.
And what is your work schedule like at the farm?
We work all day as long as it's not raining.
What months, I guess I should ask, what months are you scheduled to be in North Dakota on the farm?
April and May, and August, September, October, and November.
Does that coincide with planting and harvesting of crops?
Yes.
And was this employment you had prior to the divorce, during the divorce? When did that start in relation to the termination of the marriage?
I got it after the divorce papers were filed, but prior to the divorce being final.
Okay. Are you under contract for this upcoming season, what I would classify the 2021 harvest season?
Yes.
And so when do you then have to leave for the first part of your contract?
April 1st, I'm supposed to arrive.
Okay. And you return from that the planting part of the season when?
June 1st.
Okay. So you have to leave relatively soon to honor your contract.
Yes.
And so this schedule, that the original schedule in the judgment of divorce, when that was developed, you already had this job, correct?
Yes.
Now, what is your educational experience?
I have a master's degree.
Okay. When was the last time you used that degree?
2000, February of 2008.
And what was the job that you had using that degree?
I was in banking.
Okay. And have you held any type of banking job or employment since you left?
No.
during the marriage, when you were in Clare, residing in Clare County with your wife or ex-wife, excuse me, at the former marital home, what type of employment were the two of you engaged in?
We were semi-retired and we were trying to start a small cattle operation.
Okay. So you were already in the farming type industry before you got this current job?
Yes.
After the divorce, have you been in a financial status that you have to work? Do you need to work to survive?
Yes.
And so why did you then take a job farming in a different state?
Because our agreement was that we would each have the children half of the year. So it allowed me to go out and basically cram an entire year's worth of work into 6 months. So then when I'm here in Michigan with the kids, I'm able to spend 100% of my time with them.
Okay, going on there.
Laura, you're making noise. Can you stop?
I am. I'm sorry. I'm sorry. I apologize.
Were you able to find employment, farming employment, making the same amount of money in the Clare area as you do in North Dakota?
No.
So what are the names of the children you have in common with the plaintiff?
Reagan Marie Summers and Mason Richard Summers.
Okay. And so what is the current custody arrangement that you have ordered between you and Ms. Maselli?
Joint legal and physical.
Okay. Now, can you explain the current parent or the parenting time arrangement that was in the judgment of divorce?
I would have the kids November 1st through March 31st and June 1st through July 31st. She would have them the other months. And we allowed visitation whenever the other parent wanted it.
Okay. And I think we've covered, but to be clear, how was this agreement developed between you two?
I don't recall exactly. We had to come up with something. And so obviously the work schedule is what was, I tried to work around it.
So your work schedule was taken into consideration?
Absolutely, yes.
And this was a schedule that the two of you came up with? It was not court ordered?
That's correct.
When you were coming up with that schedule, did you ever threaten the plaintiff or anything of that nature to force her into the schedule?
No.
And when the schedule was developed, were you both represented by attorneys?
Yes.
And you were both able to consult with your attorneys prior to agreeing to the custody arrangement?
Yes.
Do you believe that the parenting time agreement contained in the judgment of divorce is in the best interest of the children?
I do.
Do you believe the arrangement, excuse me, when you have under the arrangement that's in the judgment of divorce, when the children come back to you and you become the custodial parent, are the children happy to see you during your parenting time?
Yes. We had some issues last spring, but since then it's been good.
Okay. And when they're with you, do you tell your children, when you're the custodial parent, do you tell the children you love them?
Absolutely, every day.
When they're in the care of their mother, do you try to communicate to the children that you love them?
Yes.
When they're with you, how do the children respond to you telling them that you love them?
In kind, same, they say it back.
Can you explain to the court what type of activities you and the children do together?
We play video games, we play board games, we go to the park, we play football, sailing now, just general stuff, I guess.
And when they're with you, you are not working, correct?
That's correct.
So are you then devoting all of your attention to the children?
Yes.
Was the agreement, the parenting time agreement, as you just described it, being followed by you and the plaintiff?
Yes.
Now, but was it being followed exactly how it was written in the judgment of divorce?
I believe for the most part, I mean, I came back for a week once and was able to hang out with the kids and things like that, you know, or my day coming back might be 1 or 2 days off, but for the most part, yes.
Now there was a provision in the judgment of divorce pertaining to reasonable parenting time. Was that being followed?
No, in fact, I don't believe that I even ever read it. I thought that that was much the same as the language about the Hague Convention verbiage in the custody agreement. So I haven't read that either. My understanding of it was that we were supposed to foster a relationship with the other parent, and if the other parent wanted to see the kids, that we should do everything we can to make that available within reason.
You're talking when they are when you're the custodial
Right,
parent, correct?
right.
Is that what you're talking
Yeah,
about?
when the kids are with me, if their mom wanted to see them, I made a point to make sure she could see them.
Okay. But you were not following any type of parenting time policy?
No.
Okay. And when did you begin to follow, or was it mandated, or did it change to following some type of reasonable parenting time policy?
Well, the Clare County policy was after our June hearing.
Okay. And what was the June hearing for?
Miss Maselli did not want me to take the kids out of state, take them on a sailboat, and she wanted to switch the schedule to switching off every other week.
Okay. And do you recall what the result of that motion hearing was?
Those 3 requests were denied.
Okay. But it was after that hearing that, I guess I should ask, who insisted on following this policy?
Well, the referee had brought it to our attention that there was a Clare County schedule, and then after that, Miss Maselli wanted to go by that and disregard our previous agreement.
Okay. Now, was there any event or change that occurred in your life that coincides with when Miss Maselli filed a motion, her June motion for change of custody?
The only thing that really changed was I started seeing someone in the spring this year, and I had bought the sailboat the prior fall.
Okay. Now, when you followed what I'm calling the agreed plan, not the policy part of this, were each of you provided an opportunity to see the kids when they were in the custody of the other parent?
Yes.
And now when the children were with you, did you provide updates on the children to Miss Maselli?
Yes.
Would you keep Miss Maselli updated on school and school activities?
Yes.
were you, as the custodial parent, involved with school as far as teaching or helping with homework or communicating with teachers?
Yep. And the year before, I volunteered at each of the kids' classes every week.
Okay. Were there any problems when the schedule was being practiced this way?
With the schedule, no. I didn't feel there was.
Now, after Ms. Maselli insisted on following the policy, did you agree with her interpretation?
No.
Did you follow it though?
Yes.
Why, if you didn't agree with it, why did you follow?
Well, because I thought that it was in the spirit of being cooperative and giving her visitation rights to the kids. I wasn't interested in trying to alienate her from the kids.
And on or about August 8th of 2020, do you recall a telephone conversation you had with Miss Maselli?
Yes.
Can you explain what happened during that conversation?
Yes, she explained to me I had repeatedly been trying to get a hold of the kids to talk to them and repeatedly being ignored. I think I had some 20-some calls in, and I'd only been able to reach them 4 times. And she explained to me that if I wanted to communicate with the children, I needed to show up and pick them up to see them in person every other weekend or Wednesdays from 4 to 8 p.m.
And this was when the children were in her care, correct?
Correct. And I was in North Dakota.
Okay. And does the court have the exhibits that I had emailed earlier?
Yes.
Okay. Mr. Summers, I'm handing you what's been marked as defendants 1 in the top right-hand corner. Can you explain or describe what this is?
This was a text message exchange between Laura and myself.
And how can you identify that this is a message with Laura?
Her name's at the top of the page, and I printed this from my phone.
Okay. And which side of the conversation is you talking versus Miss Maselli?
I am on the right and she's on the left.
Okay. And this is a screenshot from your phone?
Yes.
Is it a fair and accurate depiction of the conversation that took place?
Yes.
And I'd move to admit exhibit 1.
Mr. Miles, any objection or voir dire?
Just brief voir dire, Your Honor. Mr. Summers, when did that conversation take place?
I believe the conversation was on the 8th, and this was, I don't see a date. It says August 2nd, I believe, at the top. So I'm assuming that's when this was. I can go back and look at my phone if you like.
Was it, can you ballpark it for me? Was it recent or was it months ago?
Oh, no, I believe it was August 2nd. It was around the same time.
August, okay. And we've had hearings before or since then, true?
Yes, December.
Okay, December. Yeah, there was a hearing in December, and wasn't there one even after that? There's this is the objection. So the hearing in December, that's the one where Laura represented herself, true?
Yeah, I believe so, yes.
Okay. Why hadn't you brought that up at those previous hearings if you planned on using this as evidence?
We did, I believe. I believe they were submitted as evidence in those hearings.
I did get them through email, but Judge, but that was the first time I had seen those. And I would object because he could have had these admitted at the last hearing, but they chose not to.
Well, this is a brand new hearing. When you object to the front of the court hearing, so a brand new hearing, so your objection is overruled.
May I proceed, Your Honor?
You may. So B1 is admitted.
Mr. Summers, on this conversation on the left side, can you identify, you said the left side was Miss Maselli.
Yep.
Does she make any indication to you on when you're allowed to see the children?
Yes, you are allowed to see them Wednesdays from 4 to 8 p.m. and every other weekend for the whole weekend.
And was this in response to you asking her to speak to the children?
Yes.
Okay. Now, just so we're clear, it looks as if there's a date on here of August 2nd, 2020. But this conversation where she told you you could see them Wednesday, to the best of your knowledge, took place after your August 8th phone call?
I believe this was a text message, and on the 2nd and the 8th was our phone call, where she told me basically the same thing.
Okay. And so obviously this was an issue that you've had communicating with the children since the June recommendation that came out?
Yes.
Have you, despite this message from Ms. Maselli, did you continue to have, try to communicate with the children while they were with the plaintiff?
I did for a time, and I received another message later. I don't exactly know when. It basically said, stop calling me.
And did you have other members of your family trying to talk to the kids?
Yes, my parents and my aunts were trying to reach the kids as well for birthdays and such.
And to your knowledge, were the children allowed to speak to them?
To my knowledge, yes.
Okay. I'm handing you what's been marked as Defendant's Exhibit 2. Which is two pages. It's marked as Defendants 2 and 2A. Can you explain to the court what this is?
Yes, this is what I was just referencing. It's a text message from Laura. I don't know the date.
And how do you know this is a message from Laura?
Her name is at the top, and it was a screenshot from my phone.
Okay. And this piece of evidence was entered into evidence at the front of the court hearing, correct?
Yes.
Yeah. And to your knowledge, is this a fair and accurate description of the conversation that took place between, or the message that Ms. Maselli sent you?
Yes.
Your Honor, I move to admit Defendant's Exhibit 2.
Any objection or voir dire, Mr. Miles?
No, Your Honor, that was admitted at the referee hearing, so I have no objection.
All right, it's admitted.
And can you briefly for the court give the gist or the synopsis of what this message to you stated without reading the entire thing into the record?
Yep. Basically, it says you stop calling. You're able to visit with them every Wednesday and have a sleepover every other weekend.
Okay. And did it say anything regarding communication with family?
Yeah, please tell your family not to call either.
Based on your interactions with the plaintiff, Ms. Maselli, do you believe she's attempted to encourage a relationship between the children and you?
No.
And can you explain why you feel that way?
There were several items that the kids brought to my attention as far as things were contained in our property settlement agreement that they asked me about that I didn't think was appropriate for the kids to be aware of. They were talking about how one side of her side of the family had better genes than mine, and she was smarter than me, and that they could use her name while they were with her.
And was there anything that came to your attention that led you to believe that your children were using her maiden name over their given surname?
Yes, when I logged into an app at the school, my son was listed as Mason Maselli.
And is this an app that's specific to the school, or what is the name of this app?
Blooms.
And this is an app used by which school?
Claire Primary.
And is this something that you set up?
No, I'm just a user.
Okay. I'm handing you what's been marked as Defendant's Exhibit 3. And can you describe what this is?
This is a screenshot of the settings page that I saw the first time that I logged into it.
Okay. And is this?
I'm sorry. I did not get that answer at all. What was the answer?
It was a screenshot of the app the first time I logged into it.
Okay, thank you.
And is this for your login?
It was for my login.
And is there a way that on this screenshot that identifies that it's your user?
At the top, it has my name right under where it says Blooms.
And you did say that you accessed this account.
Yes.
And was this presented at the front of the court hearing?
Yes.
And was it admitted into evidence?
Yes.
And does this fairly and accurately depict the Blooms app when you logged in?
Yes.
I move to admit Defendant 3.
Any objection or voir dire, Mr. Miles?
No, Your Honor, it was previously admitted. No objection.
D3 is admitted.
Thank you, Your Honor. And so, Mr. Summers, does this list your children?
Yes.
And are your children identified with their legal name, last name of Summers?
The prior year, it is correct. This year's Mason is listed as Mason Maselli.
Okay. And did you list them as Mason Maselli?
I did not.
Okay. And so this, because it lists Mason's name twice, you're saying the one that says Mason Maselli is for this school year?
That's correct.
Just because I can't remember if I covered it or not, but when the children are with you, do you make opportunities available to Miss Maselli to see the children?
Yes, I did prior to the June hearing. After the June hearing, because it was structured, then not as much. I offered for them to go over to her aunt and uncles in Gladwin on 4th of July, but she declined.
So let me look before, under the original agreement that you guys have been following, and you were being reasonable and co-parenting, would you offer to Miss Maselli the opportunity to have the children while they were in your care?
Yes.
Did she take you up on all those opportunities?
Sometimes, not always.
Okay. At any time, did Miss Maselli ask to see the children while they were in your care? And did you deny her that opportunity?
Not to my knowledge, no.
Now, since the last order, has she asked to see the children while they're in your care?
only under the structured time.
Okay, and have you denied her?
No,
And so do you believe that you encourage a relationship between the children and their mother?
I try to.
Can you explain how you do that?
I make it a point not to discuss things that I think would be negative or demeaning. I ask them about things that I know are going on with their life, about their pets and the farm and those type of things.
If prior Miss Maselli, when you were following the original schedule, if Miss Maselli tried to call, would you make sure that the children return the call?
Yes.
Now, if you weren't able to, under this proposed or the recommended schedule from the referee, which is 2 weeks on, 2 weeks off, year round, are you able to comply with that order?
I am not able to comply with the order and keep my job.
Okay. And does this current job provide you an opportunity to be with the children more than other jobs?
I believe significantly more.
Have you had previously been a over-the-road driver, is that correct?
Yeah, we own a small trucking company together.
And so you're familiar with how much time away you would be much time away from home that job would take?
Yes.
And do you believe that the current job at the commercial farm provides you more opportunities with the children than an over-the-road trucker?
Absolutely.
Do you believe you've looked into other jobs other than the farming, is that correct?
Yes.
And do those jobs provide you with the income that the farm would?
If I worked a full year, yes.
Would it provide you with the same amount or same ability to be present with the children?
No, I would have fewer hours with them.
And you're a smart guy. So have you engaged in an analysis or creating a table of available time compared to the jobs you looked at?
As a matter of fact, I have.
I'm handing you what is defendant's proposed exhibit 6. And is this the schedule or table that you created?
Yes.
Is this a accurate depiction of your research that you've engaged in?
Yes.
Your Honor, I move to have this admitted as demonstrative evidence as to the testimony he's given for availability of time that he has in a current arrangement versus over-the-road trucking or
Any objection or voir dire, Mr. Miles?
I have no objection, Judge. These tables are commonly used. I believe it was entered previously as well.
All right, D6 is admitted.
And so just to be clear, the working on the commercial farm provides you more time and ability to be present in the children's lives than other jobs.
That's correct.
In order for you to comply with the friend of the court recommendation, would you be required to quit your job?
Yes.
If you are under contract Are you able to quit your job for this upcoming year?
No,
Do you or the plaintiff smoke?
I do not. I believe she does.
In general, do you have a problem with someone that smokes?
I'm gonna object to relevance, Your Honor.
Relevance?
Your Honor, this is the basis of Mr. Summers' original motion that he filed where we had asked for relief from the court to receive a condition on parenting time. The friend of the court's recommendation was silent on this as to either yes or no on placing the condition on parenting time. This is absolutely the issue is the plaintiff smoking in confined spaces, her defiance to not do that with the children present, and it relates to the health and safety of the minor children, which is absolutely relevant to their best interests.
All right. Any rebuttal on the objection?
Just that the referee did consider that, found it to be irrelevant, found there to be no jurisdiction to issue an order over that. But that would be my legal basis, Your Honor.
Court's gonna admit it along with over the objection.
Mr. I think the question I left off on is, do you have a problem with an adult smoking in general?
No.
Okay. Do you have concerns about your children being exposed to secondhand smoke?
Yes.
And what are those concerns?
I don't want them to be exposed to it because I think it's unhealthy. And also I don't want them to become addicted and be young smokers.
Have you attempted to address those concerns with Ms. Maselli?
Yes.
How has she responded to that?
She has disagreed with my opinion.
Okay. Has she been willing to not smoke in front of the children or in a confined space with them?
I believe, I don't know for sure, but I believe she continues to do so.
Okay. And so you're not looking for an order from the court to prevent her from smoking at all?
No.
What is the condition on parenting time that you would be asking for?
That she does not smoke in confined spaces with them present.
Okay. So if the children aren't home and she wants to smoke in her house, there's no problem with that, right?
I'm not correct.
Okay. Now,
I have a question. What kind of confined spaces are you talking about?
In the house, in the barn, in the car.
You just said you didn't have any objection to her smoking in the house.
Well, the children are present.
I had asked them if the children.
So if the children are in their bedrooms and she's in the living room or kitchen, you still object to her smoking?
Well, I do, but I mean.
Okay. You may proceed, Mr. Duso.
Thank you, Your Honor. Now, there was another issue that you raised in your original motion, and that was concerning tax exemptions for dependents.
Mm-hmm.
Is that right?
Yes.
And to your knowledge, does the judgment of divorce address who may claim children for purposes of taxes?
It does not.
Okay. And did you attempt to discuss this issue with Ms. Maselli?
Yes, I did.
And what happened during that conversation?
Originally, I notified her and asked her about it. She was not employed at the time or filing a tax return. So I asked that if I could deduct the children. She said yes. And she said, but if it changes, if I get a job, I'd like to, deduct them as well. And I said, no problem with that. This past year, she told me that she wanted to deduct both of them. And I said, well, let's each deduct one. I think that's fair. And she declined and said she was going to deduct both of them anyway, because she believed that she had more overnights. And I was told that she discussed it with her CPA. I also discussed it with my CPA, and he said it was about support. And so I believe that it was my right as well to deduct them. So we don't seem to be able to agree on that.
And so, to your knowledge, you both have a tax professional advising you that you both can claim the children.
I believe that's the case.
And so what is it that you're proposing that the court modify or order as it pertains to the tax exemption?
That we both get to deduct one.
And when there's only one child remaining, what is your proposal on how that would be handled?
We alternate years.
Did you receive stimulus money as part of the CARES Act?
Yes.
And did you offer to give Ms. Maselli the money from the stimulus?
Yes.
And how did she respond to that?
She initially was appreciative, and then she declined to accept it.
Okay. So she declined the stimulus money, but then wanted to claim the children?
I guess so, yes.
Okay.
So just to be clear, this was the offer of the stimulus check for taking the deduction on the tax return, is that correct?
No, those are unrelated.
Oh, they're unrelated. Okay.
When I got back from work, I had a check in my mailbox. And so I offered to give her the money from one of the kids. I think, was it $500? Something like that.
You were just trying to be nice?
I was trying to be nice.
Now, I need to be clear here. Did you draft a letter on your feelings on this case?
Yes.
And was this what I'm handing you as defendants 5?
Yes.
Your Honor, I'm going to move to admit defendants, move to admit defendants exhibit 5, again, as demonstrative evidence, as this letter encapsulates Mr. Summers' testimony, or as to everything that he's testified to.
Any objection or voir dire, Mr. Miles?
Well, Judge, I think I don't have an objection, I guess. It's all it does is restate what they put in their motion and what Mr. Summers has said here today. So I don't know how much weight the court would give that anyway. So no objection.
All right, D5 is admitted.
Now, you originally filed your motion for change of parenting time. Are you asking for a change of custody?
No.
Are you attempting to reduce the amount of time that the children have with their mother from compared to when the judgment of divorce was entered?
No.
And so are you wanting then the parenting time schedule that you developed with the plaintiff and actually practiced initially to stay the same?
Yes.
And so can you explain to the court what that means to you, what that schedule means to you?
That I would have the the kids from December 1st through March 31st, June 1st through July 31st. And I'm happy to allow visitation. And I would appreciate the same if I'm able to get off work and come back like I did before and visit. And I'd like to be able to communicate with the kids when I'm at work.
And if you're at work, how does that communication have to take place?
It would have to be by phone or video chat.
And have you previously provided the children with a means to communicate with you?
Yes.
And what was that?
I got them both telephones, cell phones.
Okay. And when they were able to use those phones, were you able to effectively communicate with the children while they were in their mother's care?
The first year that they had the phones, this past year, she would not let them have the phones while they were in her care.
And this was an issue that came up during Miss Maselli's motion in June, right?
Yeah, I believe it in the springtime when I went to work was the first time that she disallowed them from having their phones.
I guess the point I'm getting at is that when the children had their phones and Miss Maselli didn't take them away, there was a good communication between you and the children while you were gone.
Yes.
And do you believe that allowed you to continue and foster a relationship with the children?
Yes.
And do you believe that ability allowed the original schedule to work effectively?
Yes.
And so when the children were with you, was she being Miss Maselli, able to use those phones to communicate with the children?
Yes, she could call and text them directly.
Okay. And do you believe that helped the children foster a relationship with their mother while they were in your care?
Yes.
And this was on top of their ability or Miss Maselli's ability to see the kids?
Yes.
Do you believe that the recommended order from the friend of the court is in the best interest of your children?
No.
And you are not able to comply with that order, is that correct?
That's correct.
At least I should say you're not able to, for this year, comply with that order.
That's correct.
Do you believe there's anything else that is there anything else you would like to tell the court that you believe is relevant to your motion?
No.
Your Honor, I have nothing further on direct.
Mr. Miles?
Yes, thank you, Your Honor. Mr. Summers, when were you divorced, sir?
I believe it was in final January of 2019.
Of 2019?
Yes.
Okay, so not that long ago then, true?
2+ years ago.
Right, and we've had probably 4 or 5, 6 motions filed in that amount of time with regard to the current parenting time order. Is that true?
I'm only aware of 2.
Okay, you filed one, Ms. Maselli filed one. There was, I think she had filed a previous one, and then we're here on this objection, true?
Yes.
Okay, so you yourself even disagree that prior order was working, otherwise you wouldn't have filed a motion to modify it, true?
The part that didn't work was the verbiage of the Clare County reasonable parenting time policy. That neither
Okay,
of us,
which was part of the order, true? That was part of the order. And you had an attorney at that time, true?
True.
Any reason why you didn't read that provision?
Again, I thought it was the fine print, like the Hague Convention verbiage.
Did you have any questions for your attorney regarding the parenting time provisions?
I don't recall.
Okay. And you testified that you took this job, I think, was it Montana, you said?
North Dakota.
North Dakota. And how much do you make at that job?
It varies a little bit, but I think it's about around 40.
40,000? Is that your gross or net?
That is my net.
Okay. So that's your take home pay?
Yeah.
Okay. Do you know what your gross is?
No.
Okay. What were you making while you were banking here in Michigan?
I was never banking in Michigan.
Where were you banking at?
Colorado.
How much were you making while you were banking?
I believe that I was making 115, I think.
Okay. Any specific reason why you aren't using your education in the banking field today?
When I met Miss Maselli, we decided to start a trucking company. So we started a business. And so I haven't used my banking, I guess, experience is irrelevant at this point. I don't have contacts. I don't have a client base. I don't have anything that you need to do that job.
Well, have you applied
And quite
to any
frankly,
banks?
I
or-
probably, no, I haven't.
Okay. Why not?
I'm not interested in banking anymore.
Okay. Even though you could get a job here locally in Michigan and potentially make more money, you just don't want to do that?
I'm not sure that I could get a job here in Michigan. I mean, maybe, I guess.
Well, you don't know if you don't try, right?
That's probably correct. Yes.
Okay. How many farms have you interviewed at here in Michigan?
0.
Okay. Why is that?
Because I have a job.
Okay. Wouldn't you prefer a job that brings you closer to your children?
I would, it would be nice, but I have it's a family farm in North Dakota. My cousins, it's a 5th generation farm. So it's personal as well.
Okay, so this is basically a selfish reason why you're choosing to farm in wherever, Montana, the Dakotas, and not being near your children.
I think it's a logical reason.
Okay. You would agree that that decision does not put the children first, right?
I think it does absolutely put the children first because I'm able to spend so much time with them when I'm here.
Okay. Do you think it's good for them to be away from one parent or the other for 4 to 6 months at a time?
I think I have to do the best that I can, you know?
Would the best you can be getting a comparable job here in Michigan so you can be closer to the children and they don't have to go a few months at a time?
That's hard to say. That's speculation.
Well, I don't think it's speculation at all. Wouldn't it be easier to see your children more and not have to have them go through months at a time, but without seeing the other parent if you lived here in Michigan?
Yes.
When the divorce was being finalized and this was being discussed, you had already taken the job in Montana, true?
Yes.
And the reason why Ms. Maselli agreed to this parenting time schedule initially was because you took the job and she was trying to work with you and said, if this works, we will try it, but if not, we'll have to modify it. Isn't that true?
No, that's not true.
Okay, but you had never tried anything like this before. Isn't that true?
The divorce part?
This was your first divorce, true?
That's correct, yes.
Okay, so you had never tried having the kids away for months at a time from each other before, true?
True.
So no one knew how it was going to work out, true?
True.
And it's worked out very poorly, true?
I think it worked out fine. I think if there was more effort made to co-parent, I don't think we'd be here today.
Okay, well, that's an issue on both sides. I would agree with you, but that's an issue. I mean, we can't just say, but for all these issues, this would be working out great. Correct?
Sure.
Okay, because we have to deal with the reality of what's going on, true?
Yes.
Do you think it's in your kid's best interest? I don't think you squarely answered this, to be away from their mother for 4 to 6 months at a time.
I don't think that would be the case, but that's not what happened. That's never been the case.
Okay, what's been the case in the past?
She was always allowed to visit them, to see them. Even now, in this current arrangement, she goes and has been able to go to school to see him if she wanted to. So she's always had access to them during my time.
Isn't it true, sir, that, well, we'll strike that. You know of another piece of litigation going on that Ms. Maselli is involved in, true?
I don't know if it's still going on or not. I know that she was part of one.
And didn't you tell Ms. Maselli that you were going to lie in that case to hurt her case if she did not agree with what you wanted to propose here?
Objection, Your Honor. I'm not sure what the relevance of another case is to this one.
Why don't you rephrase your question to point out what the relevance is?
Well, Judge, it's the relevance would be for impeachment purposes. He's telling her that he's going to go under oath and lie in a different case. I think it goes to the veracity of his testimony as a whole, if that's what if he admits to that.
Well, you allege sort of to affect this case. How? Was it blackmail? What's he trying to get her to do something? That's the relevance. What is the relevance of it?
The relevance of it is, Judge, his testimony, it undercuts the rest of his testimony. If he's willing to do that and perjure himself.
You're not actually, from your statement of what the original question was, you're not really going for that. You're going after whether or not he's a truthful person.
Correct.
Is that correct? Okay, so you're changing your direction from your question that you actually asked. So the objection is sustained on the original question, so ask a new question.
Mr. Summers, are you a truthful person?
I try to be.
Would you ever lie under oath?
No.
Isn't it true that you told Ms. Maselli you were going to lie under oath in a different case to help you in this case if she didn't do what you wanted her to do in this case?
I don't believe I ever did that. She claims that she has some recording, which I don't even know of.
You don't believe you did, but you could have, right?
I don't recall ever doing that.
So, sir, you live in
that doesn't make it her guilty of killing me, right?
I don't think you get to ask the questions here, sir. You live in Montana half the year. What is your address there?
Let's get this straight. It's not Montana, it's North Dakota. Isn't that correct, Mr. Summers?
It is, Your Honor.
Okay, you've mentioned that several times. I've seen Colorado come up a couple of times, but Colorado apparently was where he did banking. So let's try and keep the facts straight.
You live in North Dakota. What's your address in North Dakota?
Give me 1 second, I'll look it up. (2487) A is in Apple, 4th Street Southwest, Washburn, North Dakota, 58577.
And how about your Michigan address?
4314 East Monroe Road, Midland, 48642.
So you're paying rent at 2 different places on a $40,000 a year salary, Mr. Summers?
Yes.
Okay. And your testimony on direct was you make more money farming in North Dakota, but that's just not true, is it?
if I could find a job here for 6 months, then that would be something. But I want to be able to hang out with my kids for the 6 months that I have with them. It's a lifestyle choice for me.
There are farms here in Michigan, true?
Yes.
Why wouldn't you look for a farm here in Michigan? Though we have seasons like they do, I would presume, in
All
North
right,
Dakota.
Let's move on, Mr. Miles, because I think you're beating a dead horse, and I think there's Exhibit 6 sort of delineates his reason for taking this job.
Sir, in your motion, your attorney cites the Internal Revenue Code with regard to exemptions, child exemptions. Do you agree that the parent that has the most overnights should get the exemption?
I was explained it was the parent that gives the most support. Overnight.
I didn't hear any.
Can you hear me now?
I can't hear the witness, Your Honor. I don't know if everyone else can.
We can hear him.
Sorry, I think that was on my end. Mr. Summers, could you restate your answer? I think everyone else could hear, but I could not.
My attorney explained to me it was which parent gave the most support. Overnights is just one of the things that they look at.
Okay.
Per my CPA.
Now, with regard to Ms. Maselli not giving additional time that's hers to you, she was merely just saying to follow the current parenting time order, true?
I'm not clear on what your question is.
You had indicated that she doesn't facilitate a relationship between you and the children, but in reality, she would just be telling you, let's follow the parenting time order because we've been having so many issues. Is that right?
No, what I was referring to was me being able to talk to my kids when I'm away at work.
Okay, and there's no provision in the order that allows for that, true?
I don't, not to my knowledge. Again, I thought that fell under the reasonable parenting time guidelines to foster a relationship with the other parent.
Sir, when you screenshotted the app, which was attached as or admitted as an exhibit, when did you do that?
Can I get clarity on, are you talking about Defendants 3, the Blooms app?
Yes, correct.
Okay, I just want to make sure he had it.
I'm going to have to go look up if you want the specific date. I believe it was sometime in September, but I'd have to go try to find it.
Okay. But you don't know who changed Mason's last name from Summers to Maselli, do you?
I do not know. It could have been him. It could have been the teacher, the school. It could have been her. I don't know. I changed it back from Maselli to Summers, though. I did that.
Okay, so you don't want the court to take your testimony as an allegation that my client did that?
No, I don't know who did it.
Okay.
I'm gonna stop here right now. I'm gonna take a break. I had scheduled another hearing for 2:15. And that should only take 15, 20 minutes, so we'll resume this hearing at 2:35. All right,
Yes, Your Honor.
we're in recess.
55th Circuit Court is now in session.
You may be seated. All right, Mr. Summers, you're still under oath, and you may proceed, Mr. Miles.
Thank you, Your Honor. Mr. Summers, you're aware that your children had to be admitted to therapy because they were having a difficult time coping with the parenting time schedule, true?
That was elective. I never thought that to be necessary.
But they are in therapy, true?
No, they are not currently. To my knowledge, they're not.
Well, if they're not, they were, true?
I believe she may have taken them a few times. Beyond that, I don't know anything about that.
Okay, you never talked to their therapist to see how they were doing?
I talked to her one time to give her a status because she called and said there was an appointment that we did not go to. I told her what the
Okay.
status was. It was during the hearing date this summer.
Okay. So you don't know what they were going for then?
No, I've never been given any information on that.
Okay. Do you agree, sir, that the children are very happy now with the current order that's been revised?
Do I agree that they're very happy with it? We haven't discussed the order in particular, so I don't know if they're happy or not about it.
You haven't discussed that the parenting time is changed?
Yeah, but I haven't asked them if they're happy about it or not.
Okay. Okay, I have no further questions, Your Honor.
Any redirect, Mr. Dusso?
We'll attempt to be brief, Your Honor. Mr. Summers, you mentioned that the order, there was a question about whether the order was working or not working. Do you believe the order worked as you actually practiced it after the judgment of divorce entered?
Yes.
And the issue and why you brought the motion was that the inclusion of when Ms. Maselli wanted to, or read the order and wanted to actually use the policy provision, that's when it did not work.
That's when everything came apart, yes.
Okay. Now, to your knowledge, is there a commercial farm in the Clare area or mid-Michigan area of the size and production that your farm in North Dakota is?
To my knowledge, there is not, and I just looked it up at break. The average US farm size is 444 acres. In Michigan, it's 211, and we farm 30,000 acres.
So you're on a significant farm. I mean, this is not a small operation. This is a large scale commercial farm.
That's correct.
Okay. And now, just to be clear, you had mentioned that your attorney had advised you about it's who supports the children. Was that a CPA or an attorney?
I misspoke. That was my CPA, not my attorney.
Okay. And would you lie under oath?
No.
Would you lie under oath for Ms. Maselli?
No.
Would you lie under oath if it was mutually beneficial?
No.
And this issue of counseling that was you just testified to, was this not actually an issue that came up during Ms. Maselli's motion in June?
Yes.
And we litigated that issue during that hearing?
Yes.
And did the referee give any credence to the counseling?
I believe, no.
Okay. You did not find that to be any substantial change or cause to warrant granting Ms. Maselli's motion?
Correct.
Okay. Do you, and lastly, you believe that the schedule that you were actually practicing, that it was beneficial for the children?
Yes.
And nothing further, Your Honor.
All right. Any other witnesses you want to call, Mr. Dusso?
No, Your Honor.
All right. Mr. Miles, any witnesses you wish to call?
Yes, Your Honor, I would call Ms. Maselli at this time.
All right. Ms. Maselli, please raise your right hand and be sworn.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Ms. Maselli, you had heard Mr. Summers testify that the order had been working between the two of you. Did you hear that?
I did hear that.
Would you agree or disagree with that statement?
I wholeheartedly disagree from my view. Did not work.
Okay, and why was it not working?
I had never been away from my children for such a great length of time, and it was a very, very difficult period to do that. And there was no regularity with when I would see them. Or when I could communicate. I didn't want to feel like a burden to continually ask for time and things like that. I didn't want to interrupt his time and seem needy. It was a really confusing scenario, and it was very emotionally difficult for me. And I also noticed that when the children would come back to me for the 4 months or the 2 months, it was a way longer transition period to normalcy than this recent 2 week. There was so much change just from being with one parent or the other that it was just difficult. It wasn't bad per se, but it was a challenge, and it was it took time away from normal life because we had to adjust again on a larger scale than this 2 week scenario, which has been wonderful.
And how old are your children, Ms. Maselli?
They are 10 and 8.
And while this was going on, trying to adjust to this order, did you notice any mental or emotional issues with regard to your children adjusting?
I did. I noticed a lot of, I'm not sure how to word this, but a lot of confusion from them on they're not sure how to act because they know that their father wants a certain way and that I want a certain way. So it was always kind of tiptoey around whether they're doing the right thing or not. And I did notice at the parent-teacher conferences regarding my daughter, who is an exceptional student. She is actually the highest in her class and actually gets pulled aside to do the higher grade of learning because she's advanced. 2 weeks prior to this recent change at Christmas, the December child transfer, for lack of a more normal term, the teacher noticed that her work had declined greatly. Her neatness and her attention to detail was a huge decline, and her teacher and I discussed that. And I am not a therapist, but I attributed it to the current change because she knew that December was coming and she would have to go back to her dad, and things just change, and it's difficult to change. So I did notice on her a big the unknown. So I noticed some differences with her that her teacher noticed as well that affected her schoolwork.
Did the changes become so prevalent that you actually had them admitted into some sort of therapy?
I had at the beginning of the divorce, which of course is difficult in itself, with the timing change and parenting time, time with each parent. I was concerned for them because I had gone through a divorce and it's difficult for a child. So I wanted to put them into therapy. My son has always shown signs of aggression, somewhat. That I feel bad to say that, but I felt that I didn't want things to get much worse and wanted to mitigate anything ahead of time. But they haven't been in therapy for quite some time. I've just taken. I recently got rid of a ton of livestock that supported me a lot more time with my children. And when I do have them, we kind of do in-house therapy. We talk about things a lot. So I haven't needed outsourced therapy in a while. At the beginning, it was very difficult, but they haven't been in therapy for a while.
Okay. Did Mr. Summers ever threaten to lie under oath to punish you in a different case if he didn't get what he wanted here?
He attempted to use the children as leverage. he said that he would do whatever I can find the recording, but he said he would say whatever he needed to say in a different case that I have with a logging company, if I was willing to trade the children and trade some time. And I remember asking him, "You're kidding me? You'd lie under oath to do that?" And he said, "Hell yeah. If you're going to give me some of the, give me more time with the kids and give me what I want with the kids, then hell yeah." And I obviously have not called him as a witness in that case because I don't believe that that's the right thing to do.
Sure. Do you love your children, Laura?
With more than everything that I have, absolutely.
Your children love you,
Absolutely.
and they show
Not a
you that
doubt.
affection as well?
Constantly. My fridge is full of drawings. My basement is a mess from Lego creations. I have lots of proof of love and caring and learning going on in my house. Absolutely.
Are the kids happy about this proposed switch?
They are. I do get that Michael doesn't discuss things with them, and they ask me questions, and I'm not afraid to answer them because they have questions about it. They weren't even aware when they were going to be coming back to me. They had no idea I was going to pick them up on Sunday, and they are way happy. I ask them all the time, "Are you happy with this? Did you like the other way better?" Because they're a part of this too, and I value their opinion. They are small, but they are smart, and we all very much like the 2-week scenario. I have a different idea of something that is better, but I am thrilled with the 2-week scenario. I think it affords plenty of time, and I go the extra mile and see them on every Wednesday. I go to their school and take them out for lunch just to see their faces. It's 20 minutes, and Michael agreed that that's okay to do, and it's been working out fantastic.
Okay. Ms. Maselli, with regard to the claims that you don't facilitate a strong relationship between the children and the father, you do want to see a strong relationship between them. Isn't that true?
I do, and the 2 weeks has afforded that. It makes it so that I don't have to be responsible for Michael's time with them. He gets his own time, and I get my own time, and it's up to me to make the most of my time, and it's up to him to make the most of his. When it's a 4-month, 2-month, and I'm kind of caught in the middle of trying to decide what is best for my ex-husband, which I feel is not my responsibility. And I'm sorry, I got lost. I kind of babbled.
That's okay. The referee in this hearing prior, the referee made mention that because Michael had objected and said that there was parental alienation. Do you recall that?
I do.
That claim being made? And the referee addressed that specifically and said the way to do away with parental alienation worries is to switch to this new order. Do you agree that if one parent is alienating the other, that this is a much better schedule to have?
I do, and that aspect to me falls under the both parents' mental health. I know when I wanted to talk to the children and they weren't available, your mind wanders and you get antsy and you want to talk to them and you just can't. So I understand that stress, and I would imagine that he goes through the same scenario, but the timing was not always convenient, and it was a hindrance when he would call. And for example, if we were at a birthday party or we were doing things and I couldn't drop what we were doing to let the children talk to him, and then he became frustrated because he can't talk to him. But so to have to go back and forth and explain why the kids can't talk to him, it's been a huge hassle that is unnecessary and doesn't help with the growth of my family.
And at 8 and 10, I would imagine they're getting more involved in extracurricular activities as well and more busy. Is that true?
That is true, and they're children, so they don't stop and say, "Wow, I really miss my dad or miss my mom. I'm going to call her." They don't do that. They're doing what they're doing. They have to be guided to do that. So yes.
Right. And you would request that the court uphold the referee's findings and the proposed change in parenting time?
I would hope that happens. Yes, sir.
And you believe that's in the best interest of the minor children here?
I believe it's in the best interest of the children and the parents, because I really believe that Michael is a very smart man and he could find a job here that would afford him more than 40,000 a year. I know that he can. I've been in business dealings. I know that he's more than capable of that. And I know that not just the children's best interest, but for the parents to have some normalcy and to have some stability and peace of mind, knowing that, you can see your kids in 2 weeks and there's no question, you get to see those things. So, yes.
Sure. Thank you, Laura. I have no further questions for you.
Mr. Duso?
Thank you, Your Honor. Ms. Maselli, you just stated that the schedule, the former schedule was not working. Is that correct?
Correct.
And it was because you were away from the children, correct? And you did just say that, correct?
I believe I said there were several factors.
I know. But one of them was that you were away from the children.
That is one factor that has affected, absolutely, yes.
And you did not have regularity or did not feel that you had regularity in seeing the children, correct?
That's correct. I'm a part of this family as well, yes.
And it was very difficult for you. Is that correct?
Yes, it was very difficult.
So the difficulty with the schedule was about you, correct?
As I stated already, I believe there were more points to than just one. Okay. That is part of it, if that was your question.
Yeah. Now, you indicated that the transition when the children go from you to back to Mr. Summers to you, under the original plan, it wasn't that bad. Is that correct? That's what you just stated.
I believe I stated several other things. Didn't I already state it on the record?
I'm just clarifying that you said it wasn't that bad under the original plan, but it's maybe a little better now.
I always want the best for my children, and I don't think that is the best scenario. And if there's an option to do things differently, then I would go with that option if I could. And so yes, it wasn't the worst ever. I don't know what scale we're using here to clarify what is good and bad, but I do know that it wasn't the worst in the world, but it definitely was not the best.
Okay. And now you said you've been doing, I think you called it like in-house therapy with the children. Is that correct?
I don't see my screen now. Maybe I should clarify that as living life and speaking and communicating with my children. So yes, I do that.
Okay. And in your in-house therapy, isn't it true that you are telling the children about the issues you are having? Isn't that true?
My children see me working 18 hours a day. My children have seen me building things, fixing machinery, dealing with 100 head of livestock alone. They see me work incessantly. They see me in physical pain. They see me in financial pain. They see those things and they ask questions. They want to help me because they see their mother in pain. So yes, we discuss those. I don't just push them away into their room. I do talk freely about scenarios because my life growing up, I was left in the dark and I did not want to raise my children that way.
So as an 8 and 10-year-old, you are openly discussing and deflecting on them your financial issues.
I will tell you that I did not do that until they said to me, "Wow, mommy, I never knew that because I thought you were always the bad guy." I said, "What do you mean I'm the bad guy?" I said, "Well, daddy told me you never wanted them here in all sorts of scenarios." So once that door was open, I felt that the gloves came off and I reciprocated with honesty. And I don't know that that's bad. I think that's honesty, and their children, yes, but they can handle the truth. They can handle more than you think they can.
So in December, when you talked about your daughter having issues at school,
Mhm.
this was before the Mr. Summers motion was heard, correct?
That's correct. This is when the kids were going back to their father, not when they were coming back to me.
And so the children are with you, correct? In December?
No, they go back with him in December 1st.
Oh, so the issue with the teacher was before December?
That's correct, before they went back with their father.
And so before they go back with their father and during your in-house therapy sessions, when you discuss your issues with them, or you're honest with them about the issues, correct?
I don't understand your question, sir.
Your daughter was allegedly having an issue at school, correct?
Is that a question? Is that your
Yes.
question? Then yes.
Okay. And before, this was also when they were in your care, correct?
That is correct.
Okay. And while in your care, you openly discussed issues of finance or with Mr. Summers with them, correct?
That's not correct. I cannot tell you everything I've spoken with them about, but that is not correct that I sit down with my children and we have conferences regarding my finance. That is not correct. We talk about things as to where we are going to live and how I'm going to be able to live here.
I feel as if you're conflicting, but I'm going to move on now. You indicated that you have a recording of Mr. Summers. Is that true?
That is true.
And so you then decided to illegally record Mr. Summers?
I'm gonna
No,
object, Your Honor.
actually-
That is, I'm gonna place an objection. That is not illegal in Michigan. If one party is a party. to the
Listing.
conversation.
Am I supposed to answer the question?
No,
Okay.
unless he rephrases it.
Miss Maselli, did you record Mr. Summers without his knowledge?
No, sir, I actually have a recording of him asking me if I'm recording him, and I said yes. So he was aware of the recording.
But you don't have that today, correct?
No, I don't. But I won't if there's a next time.
Ms. Maselli, at one point, when you signed the judgment of divorce, you agreed that this judgment was, or this schedule, the original schedule was in the best interest of your children, correct?
When I signed the judgment of divorce, I signed a document that was put in front of me, and there were several factors involved in the signing of that. So to answer your direct question, no, I did not think that that was the best interest of my children when I signed it.
Isn't it true that you regularly turn down Mr. Summers' offers to spend more time with the children?
I have my own life too, and I can't always drop what I'm doing because he wants me to visit them. So I don't know how to answer that question.
So you did turn down opportunities to see the children?
Yes, I did.
Okay. Now, when we were in front of the court in June on your motion to change custody, that motion denied, correct?
I never have requested to change custody, no. I don't remember asking to change custody. We have parental and physical custody. I've never asked to change that, I don't believe.
A change of parenting time.
Okay, so can you ask me again? Because I don't understand the question.
In June, when we went to the front of the court, it was on your motion to change parenting time, correct?
I don't remember. You'll have to look at the dates. I don't have that in front of me. If the motion says the date, then I suppose I did. I'm sure it's on record. I don't have that information in front of me to verify that. I
Regardless.
did file a motion, yes, but I don't know the
Okay,
date.
thank you. That's fine. And your motion was denied, correct?
That's correct.
Okay. And then you realized that the judgment included a provision pertaining to the Clare County parenting time policy. Is that correct?
That's correct.
And then since realizing that was in the judgment, you've attempted to strictly follow that policy. Is that correct?
I have scrutinized the judgment of divorce since that hearing, and I believe that I have followed it to the letter of the law of what the law has afforded me.
You would agree that attempting to follow the reasonable parenting time policy conflicts with what you had been following before, correct?
No, sir, I don't think it is conflicting. I think that it is there to help mitigate power issues or issues that may happen if one party is left in complete control of the other. I think it's there as a protection.
But you would admit that it is different from what you had actually been practicing after the judgment entered.
Correct. I was practicing the way Michael's wish, and it was not good.
And it is true that after you began strictly following this policy, that you advised Mr. Summers that he could visit his children on Wednesday evenings?
I don't remember saying that he could visit. I think at the time it was a matter of talking to them. And as I stated earlier, stability and normalcy of when he were to contact them was important because it was a big impact on my day-to-day working and my chores. So I used that schedule, since it had been written and agreed by both of us, as a way for him to contact the children every Wednesday. Here's your opportunity, then we can plan on that, and we can set that time aside, and you can visit on those times then. Phone visit, virtual visit then. I had no problem with that. I don't believe, I don't remember, and that's something I don't believe that I said he never allowed to contact your children or any such words like that.
Now, you had an opportunity to have the exhibits that were admitted. You have a copy of those, correct?
I do not have them in front of me. No, I'm sorry.
Okay. But you remember them from our first hearing?
Perhaps. I don't know what you're referring to.
Well, I'm referring to Exhibit 2A, Defendant's Exhibit 2A. And isn't it true you texted to Mr. Summers, you are able to visit with the kids every Wednesday for 4 hours and a sleepover every other weekend. Because you are not here does not mean I get the added responsibility to take care of your feelings. Do you remember saying that?
I don't remember saying that, and I don't remember what was said prior to that either. I can't recollect that, but I'm assuming you have it in front of you, so.
Okay, do you remember also in that text message telling Mr. Summers, all that being said, please do not call to chat with them when they are on my time, and have your family do the same?
Yes, I do remember that. Again.
So you just testified that it was call and chat on the schedule, and yet you texted him, do not call me when the children are with me.
I guess what is written is written. I don't know what your question is. I don't remember the details of it. That's what the evidence is for, and I don't have any of that in front of me to guarantee validity of your questions. I'm sorry, I can't answer that.
Wouldn't you agree it's important for Mr. Summers to be able to talk to his children when they are with you?
No, not under the current schedule. I believe that 2 weeks has been great. So no, I do not.
you would agree that parenting time disputes are between children and should not involve the children, or excuse me, the parenting time disputes are between the parents and should not involve the children, correct?
I don't agree with that. I believe that parenting time in the whole word of parenting involves children and parents and family. So I do believe that they should have a part in it. That's my belief.
So isn't it possible then that your inclusion of the children in your parenting time disputes with Mr. Summers has had an adverse effect on your children?
I cannot answer that. I'm not a medical professional. I have not noticed anything. That's what you're asking me from a mother point of view.
Okay. I thought earlier you had mentioned that the children, your daughter had a distinguished change at school, and that was related to, in your opinion, to having to go back to her father.
Again, there are so many different scenarios that have gone on. I don't know, are you referring to the current order? Because you say current order, and the current order is 2 week, 2 week. So I have not noticed anything different or bad or wrong or what have you in the 2 week current order.
Okay. Isn't it true you've told your children that Mr. Summers is a selfish man?
Yes, that's true when it comes up.
Okay. Miss Maselli.
Thank you.
Are you employed?
I'm self-employed.
And what's your source of income?
Well, I have sold a lot of equipment and I have livestock that I've sold. And it turns out that I have to look for new employment.
And I guess prior to selling items, how were you making money then?
Livestock, I had 50 pigs and 50 cattle of high genetic that I tried to sell as high quality meat.
So
That turned out to be not a very good idea.
So farming, is that fair to say?
Yeah, livestock farming, animal farming.
And doing that line of employment, has that allowed you to spend a lot of time with your children when they're with you?
Again, I stated earlier that I got rid of the animals, and so I don't understand your question.
In the past, when you were, I guess, fully engaged in the farming, did that afford you the opportunity to spend time with the children? Compared to a structured 8 to 5 job?
I don't know. I don't know how to answer that question.
I have 1 second, Your Honor.
You may.
Ms. Maselli, under the current schedule, the current one being what the referee recommended, the 2 weeks on, 2 weeks off, just so we're clear. Would you have any objections to the children being with a third party when Mr. Summers is out of state?
I believe with the current order, it states on there in the last line or so, I don't have it in front of me, but
I'm just asking your opinion, not what the order says. I'm asking your opinion, you personally.
my opinion is that, just as the order says, that there's a fine line there. If he is going to just give my children to someone else, then I don't know that that is true parenting, and that may cause an issue down the road. So I am looking out for him and thinking that sharing parenting time with a significant other is great. I don't have any problem with his girlfriend. I've never met her, and frankly, I don't care, but I've heard that she's great. Kids like her. That's all I need to know. But if you're asking me if they can she can have them all the time, then I think that might not be a smart move, is all I can say.
And I'm curious, I'm gonna ask you a question. You believe that there's a schedule better than the one that was recommended by the friend of the court. What is that?
I think 1 week, I requested that in a previous hearing and I was denied. So that was my scenario. That's why I asked for it. But 2 weeks has been great.
Anything else? I have no further questions, Your Honor.
Redirect, Mr. Miles?
Yes, briefly, Judge. Ms. Maselli, you were questioned about talking to your children about the current parenting time schedules and things. Your children are 8 and 10. Do you believe that they are of sufficient age and maturity to be able to express a mature opinion on what they would like with regard to a parenting time schedule?
Yes, I do. They both are advanced. My son is in the 3rd grade and he's doing 6th grade math. And again, as I stated, my daughter is doing a higher level academics. I think they're very far ahead in maturity and academics. And I believe that's because partly of me.
Sure. And they prefer this 2-week schedule hands down, true?
Hands down. They love it. Their fish is still alive when they get here. The apple seed they've sprouted is still in bloom and they can see it change. Absolutely. There are several small things that are very important to them that they get to still be their witness to.
Thank you. No further questions, Your Honor.
Any other witnesses, Mr. Miles?
None, Judge.
Closing argument or rebuttal witnesses first, Mr. Dusso, any rebuttal?
No rebuttal witnesses, Your Honor.
Closing argument.
Thank you, Your Honor. There's a presumption that it's in the best interest of the child or children to have a strong relationship with both parents. While this original custody arrangement the parties created is unique, it also is one that allows or works around a out-of-state work schedule. And there's the frequency and the type and the duration of a parenting time schedule needs to be reasonably calculated to promote a strong relationship. And in the parties' view, when they entered into this agreement, that was the case. And the court is to accept a parenting time agreement that the parties come up with. Now, after the fact, Ms. Maselli doesn't like it. She's tried to change it. It was denied. And then she essentially goes from a parenting time schedule that they had been using, that they had actually been practicing, and says, well, I'm going to include the reasonable parenting time policy. But I believe the judgment just references reasonable parenting time. And it just does not mesh. You can't have every other week if the spirit of the parenting time agreement between the parties was to have equal time, to then include every other weekend and weekends in the summer, which isn't even called for in the parenting time policy. It completely destroys the purpose of the schedule. Now, the front of the court's recommendation creates a schedule that Mr. Summers absolutely cannot comply with. Not this year, not when he's under contract for employment. And as stated in my brief, it does create a change of custody situation. As I will leave, my brief speaks for Mr. Summers' arguments as well as the testament that's been made. But it's my client's view that the original schedule that the parties had followed is in the best interest of the children. Additionally, it's not uncommon for courts to place conditions on parenting time, and it is not unreasonable to ask somebody not to smoke with children in a confined space, in the car, in the house, in the barn. You can step outside. You don't need to smoke with them present. And lastly, that the court order, and the court has the authority in a child support order to each claim one child. And thirdly, they have both at separate times asked the friend of the court to create a specific time to allow for video or telecommunication with the children. Each time the parties have asked for it, the friend of the court's denied it, and yet it's probably an integral part to co-parenting for these parents. And so we'd ask that there be an order for a specific time for parenting to take place, or excuse me, video communication. If this court's not convinced that that's in the best interest of the children, Mr. Summers would ask that this court stay the enforcement of the recommendation by the friend of the court for 1 year. That will allow Mr. Summers' contract to lapse with the farm for the possibility for him to have something renegotiated or see if anything, I guess, for him to completely evaluate what he's going to do here. This recommendation of 2 weeks on, 2 weeks off was dropped on him, or it was issued from the bench in December when he was already under contract and this issue was set, he was set to go out in just a few months. So we'd ask that alternatively, this order be stayed for 1 year, go back to the original schedule, and then the recommendation can take place. Further, Your Honor, I leave the remainder of my comments that are found in the brief for the court to review. Thank you, Your Honor.
Mr. Miles?
Yes, thank you, Your Honor. I believe the referee said it best at the hearing when she said that, you know, I'm paraphrasing, but basically we're only 2 years into this and we're having these types of issues already. Something needs to change. It's not that Mr. Summers can't exercise the 2 weeks on, 2 weeks off. It's that he doesn't want to. He doesn't want to leave work, you know, on a Friday and drive and pick up the kids and then exercise his 2 weeks. He doesn't want to hire somebody for daycare to watch the children while he's at work. But not a lot of parents want to do those things. They do those things out of the best interest of their children when they have to do those things. And so he made the decision to move out of state. My client was gracious enough to agree to try this for a little while and see if it worked to try and help him out. It clearly has not been working. The referee clearly noted that as well. There have been motion after motion after motion before the court trying to get this changed, either by Ms. Maselli or by Mr. Summers. So it's clearly not been working. I think that the referee's judgment and the reasons why she did what she did are very sound. When you look at the alienation argument, which it appears Mr. Summers has completely abandoned now here today, but that was one of his biggest ones, is that Ms. Maselli is alienating the children from me. And so what do you do there? You break it up to where it's not 2-4 months at a time, and it's only 2 weeks at a time. So you only have to go 2 weeks without seeing your kids, then you see them for 2 weeks. So I think that was a great compromise that was reached by the referee, given these circumstances. As the opinion notes, which everyone I think agrees with, this agreement from the jump has been a very, very unusual agreement, and it was tried and it failed horribly. It affected everyone horribly, and I think that the best thing to do now is to move on with this 2 weeks on, 2 weeks off. The children are much happier with it. I think the parents ultimately will be much happier with it as well. And that's all I have. Thank you, Judge.
Rebuttal?
Your Honor, the idea of parental alienation was brought up by the friend of the court. And I guess a point here is that Ms. Maselli filed a motion in June to suspend summer parenting time and all the, not to allow Mr. Summers to leave the state and to change parenting time, but it was really a change of custody motion, and that's was noted in the front of the court's opinion, and it was denied. The only reason this motion was brought by Mr. Summers was because of the one sentence in the recommendation saying the party utilize the reasonable parenting time policy. And that creates a situation then that defeats the spirit and purpose of their agreement. If you look at the opinion from the friend of the court, it doesn't take into account the parenting time factors. In particular, is a parenting time schedule that has a frequency and type and duration that a party can comply with. And further, then the best interest factors that the friend of the court analyzed, two of them were clearly not in favor of the plaintiff. She doesn't promote a strong relationship, and she thought that the plaintiff may even need counseling to address her issues because it was clearly affecting her ability to parent the children. And then yet we get this recommendation of 2 weeks on, 2 weeks off that my client can't comply with because he's got a job he's had out of state, that essentially will create that he can't comply with, and now we've given her even more time with the children. This is not because Mr. Summers can't drive from North Dakota to pick up the kids, but what's unreasonable is to drive to North Dakota, from North Dakota to Michigan, pick up the kids, drive them back to North Dakota to spend 7 days, and then get back in the car and bring them back to Michigan to comply with the order. That's not in the best interest of the children. Mr. Summers could, but it's going to be continuous back and forth for children that makes no sense. Again, we ask that the recommendation be set aside and his original relief be granted. Thank you, Your Honor.
All right. Court's going to take it under advisement at this time, review the policy that the friend of the court is currently using. And there's a transcript of the part of the excerpt on the friend of the court hearing, so court will read that. And Mr. Miles, did you plan on filing some kind of response to the objection, or you're satisfied with the testimony here today and your arguments?
Judge, I believe my client, when she was pro per, had filed a response. And I got retained on this rather late in the game. Laura, did you file a response or no?
No, I did not.
Oh, I thought you did. Judge, I will get a response on file then. I was retained late in the game, and I requested an adjournment. But that's neither here nor there. But I will get a response on file if the court would allow.
Yeah, I'll give you 5 business days to get that filed.
Thank you, Judge.
Anything further from anybody?
No, Your Honor. Thank you for your time today.
None from us.
We're in recess.